February 17, 2013, you committed that offense by starting a fire uh, with the intent to destroy or damage the building of another, specifically that of Ronnie King.
Yes, sir.
Okay. Count 7, being having possession of a handgun, having been a convicted felon, how you plead.
Guilty.
And I'm going to ask you if you did possess a handgun on February 17, 2013, after having been convicted of a felon.
Yes, sir.
Okay. Count 3, being persistent felony offender in the first.
All right, how's it going, everybody? How you guys doing? Listening while cooking dinner. That sounds good. I think Mama C's getting ready to start dinner in there for us too. So eating late here again at the Collins household. Something we do. Hey, Banner B, Blue Moon, Jen, Steven, how you doing, buddy? Chaotic Beauty. How is everybody tonight? I know I missed some. Who knows? Gina. So we're going to I'm going to try to do that share screen thing here. I've been working on it today. I think I figured it out a little bit easier. We still may have some trial and error, but we will hopefully be able to do all I can share screen and still see the chat that way. Hey, Thumper, thank you. Thank you for joining. That's awesome. Hit the taco truck tonight. Oh, it's Taco Thursday. Taco Thursday. Oh, so yeah, we'll let some more come on in. And you guys want to discuss anything from the previous, what we've seen heading into tonight? We've got I think a witness or two left, and I know the expert, or not the expert, but the defense investigator still has to finish, and they have this laptop that that used to belong to Ernie, has some ID stuff on it. It really has nothing to do with murder, but they do use it to show that he's not a credible witness. So so you're going to see more of that, and it's like I said, if you're over there and you're able to be swayed and saying, hey man, is this guy possibly setting somebody up? You might sit over there with that reasonable doubt and say, okay, this, there's reasonable doubt. So there's a possibility there, and that's what the defense was going for. So like I said, I think the defense did a pretty good job of at least doing that part. I don't think it was ethical, a lot of the things they did, and that actually comes up tonight. I was previewing and naming some of the files so I could find them easy. And especially during the closing arguments, I guess it is customary or common practice for attorneys to not really object during closing arguments. The defense objects twice early in the closing arguments, and then of the prosecution, and the prosecution is like, hey, we let you sit over there and say all this stuff, and all we're doing is refuting it now, and you're going to object every time we say something. So it's, you're going to see some pretty powerful back and forth between the attorneys tonight during the bench conferences and things like that. Now, the last video of the prosecution, I won't share screen. I'll just play it because it's got the disturbing images in it, but I don't want you to miss what is being said. So I'll just play it and not share screen. That way you can hear it. So yeah, they interrupt them twice early, and I guess it kind of knocks them out of rhythm or whatever, and also, and they even, like I said, they even said a few things like, you're not supposed to comment on your closing arguments about anything that wasn't presented during trial, but you did anyway. They're talking to the defense. And the defense gets a little defensive about that, but it's pretty interesting to say the least. So you're going to see all that. We'll go ahead and start this video. If anybody comes in a little bit late, then they can, because like I said, we may have some trial and error anyway with me sharing the screen. But I'm going to go ahead and share a screen with this video player and see how that works. Okay.
Ladies and gentlemen, we're going to do something outside your presence for about 15 minutes. I apologize. I know this is it's been difficult for you. Please, if you will, step outside. Same admonition. Don't form any opinions. Don't talk among yourselves about it. And we'll be move this along as fast as we can.
Yeah, that's what the prosecution was saying, Steve. They were like, you keep interrupting us. Let's get past the security leaving here a little bit. Let me.
All right. Okay, sure. All right. Let's see what we're doing here.
Okay. We're back on the record.
We're on the record.
Plug this in.
Well, maybe we don't need to be on the record. I don't know. I want to find out what you're all talking about.
Well, Your Honor,
But I'm going to caution you. You can only testify to matters in your personal knowledge.
Yes. I believe she has personal knowledge of what came from this computer. I don't understand why it's an issue, but if it's going to be an issue.
She said someone else, wait a minute. She said someone else took this stuff off the computer.
Yeah, and gave it to her. I mean, the job is to collect evidence and talk to witnesses.
Works on computers.
It was what?
It was a gentleman that works on computers, and he took the hard drive, plugged it into a little thing he has, and pulled the information from the hard drive, put it on a flash drive, and gave it to me.
Okay.
He didn't edit it or change it.
He said that it could be dug into further if we chose to do so, but that was just the main basic hard drive.
And what kind of data was?
There were photos, anything basic off of what
If
you're.
the court will turn on the
yeah.
TV, I can show.
Photos and just files and things like that.
To give a comparison, Your Honor, I know Jeff Rogers, the expert that the Commonwealth had, is an expert, but he didn't bring in the software makers for Celebrate. He didn't bring in the people that actually extract the information from
Who are you
the phone.
talking about?
Jeff Rogers, he testified
The
earlier.
phone guy?
The phone guy. Like, for comparison's sake, his job is to get data from a phone and pull reports from it. Jessica's job was to try to get the information off the computer. He used some tools, he used some software to get that information. We didn't ask him to bring in the people that wrote up the software.
I'm not asking for that. I'm not talking about that.
We're not asking for.
We
all
got
these
an unknown person
actors.
out here who took the stuff off the computer.
Right.
Here's the second part, Your Honor, is Mr. Rogers went through the data and collected what was important and highlighted it in a format where people could read. Now, our guy did not do that. That's not been done. This is a straight.
I don't care what Mr. Rogers did. I know what objected to what Mr. Rogers did.
We didn't ask for extra explanation of how.
Well, that's
Rogers
fine.
did his job.
But
Jessica did her job. We don't think.
Hey.
Explanation for her.
That's apples and oranges.
I'm not saying it's not apples and oranges.
You didn't object to
No, I'm not
He's
objecting.
objected. He's objected.
He is
So
objecting.
now we're dealing with an objection, an evidentiary objection. And he's objecting because the guy who did this isn't here to say what he did and how he did and what he, were you there when he did it?
I was not there when he pulled it from the hard drive onto the.
No.
Your Honor, if I could just point out that the files on the computer speak for themselves. And as far as authentication goes, if the court wants to say that he ever touched this data, he didn't. There was no physical touching of the data. He just pushed it from one thing to another. There is no, he never had possession of it. He never
There's no
touched it.
link between the computer and the files and her, other than that he sent them. He sent this unknown person sent her some files.
We asked for copies.
Huh?
Basically, we asked for copies. Instead of asking for paper copies, we asked them to
Look,
make copies.
you're avoiding. You're not addressing the issue. The person is this. The guy that did this isn't here.
Right, but if you make copies with paper, you wouldn't ask for the copier to come to court. This man made a copy of the hard drive. We have a copy of the hard drive. It's an image, it's a copy.
Who can certify that it's a copy?
Nobody has.
Who can certify it's a copy?
Your Honor,
Who?
respectfully,
Answer my question,
I
please.
don't know the guy's name.
There you are.
We took it to him, he made a copy. We could take something to Kinko's and make a copy, it would be the same thing. It's a copy. It's a duplicate. They're admissible and they've been admissible forever. The fact that it's a.
You still have to
It's a
authenticate
paper copy.
things, and you have to have some kind. You have to have evidence that this is what it is purported to be.
Well, we do have that, one, the laptop was testified to by Ms. Stidham earlier. She said that Shelby shot it up in the road in front of her house. Not Shelby, sorry, Ernie.
There is no.
But we literally,
But we have that laptop. We have a big gap, and then we have you saying, or the witness prepared to say that this stuff came from that laptop, but no link between the two.
we have.
No evidentiary link between the two.
Copy of the laptop.
That's
I
it.
understand that you're probably overruling our
I am.
request to have.
I am.
this submitted.
It's overruled.
We do need to present it by a vowel, Your Honor.
Huh?
We do need to present it by a vowel, and we can also say that the laptop was dropped off and the copy was picked up, just like any copy.
You can present anything you want by vowel, but it's overruled. So start your vowel.
Okay, are we on the record?
Yes, we've always had been.
Ms. Wells, is this that is on the screen, these files, did they come from the laptop that you got from instead of?
Yes.
And I want to talk a little bit about that process. You got the laptop from Pam
Yes.
and you took it to a computer person
Yes.
and he copied that stuff and you have a copy of what was on the hard drive,
Yes.
right?
Yes. On a flash drive.
Okay. And in that, you have everything that was on that computer, right?
Yes.
It was just a copy.
Just a copy. Yes.
Okay. Is that TV on?
No, it was, it's just gone off.
That was the Elmo. Yeah, there you go.
Can you just back up a little bit for y'all see?
Can you turn off the elbow maybe too? Maybe it'll stay on.
Ms. Wells, I'm looking at some pictures of Jason masks. Can you see
Yes.
those?
Yes, I can.
And specifically, I'm gonna put on a couple of things here. This is a picture of a fugitive recovery agent image.
Yes.
And this is a fugitive recovery agent badge.
Yes.
And again, I'm not gonna open up every one of these, but just finally, can you see this one here? It says fugitive recovery agent right there,
Yes, I can.
and that was all on Ernie Shell's computer.
Yes, it was.
Okay, now I'm gonna take you to just one more set of pictures. Obviously, there's more face badges, but I'm gonna show you this one,
Yes.
That's Ernie Shell right there,
Yes, it is.
and that is a fugitive recovery agent badge.
Yes, it is.
And I'm gonna refer back to this picture.
Yes.
Can you see that?
Yes, those appear to be the same type of,
And those are all pictures you got from Ernie Shell's computer.
yes, sir, it is.
Your Honor, I'd like to move to enter the contents of this computer by avowal.
I vow.
It has been excluded.
If you want to cross, John, Mr. Lee, if you want to cross, all right. It's introduced by, by avowal, but not as evidence in this case, at least not at this time. And I'm not even sure about the relevance of it, but anyway, let's get the jury back in here.
Your Honor, if I may, I'm just so that we don't continue to do this. Do you all want to talk about what you're trying to put on through her to see if we have an objection and we can do it outside of their presence so we can be seamless?
I don't have a lot more. I mean, if you're gonna object to everything I say, then I guess we just have to keep.
Let's don't go there now. Look, the defendant has the right to put on a defense, but case after case will tell you the defense does not have an unfettered right to put on evidence that I'm not even sure how relevant this is to any of the issues in this case, and not an unfettered right to just kill time, and not an unfettered right to introduce inadmissible evidence. Period. Now we're going to move on, and Mr. Lee asked you a question a moment ago, and I'm not, Mr. Lee, I'm not quite sure what your question was.
My question was simply, I was trying to honestly help them. I say, if you have other evidence that you're going to be putting in, one of his complaints was every time I ask a question, you object. I will continue to do that. It's my job.
Well, there's been grounds for objection.
But in any event, if he wanted to, and they don't have to, go ahead and talk about what they're planning on putting through with her. I could then state now if I have an objection outside of the jury's presence. And after your rulings, the testimony may be seamless. I don't care either way. I'm still going to object if it's objectionable.
That may be a good way to go.
I'm not talking about complete testimony, Mr. Shaw. I'm just talking about if you have other pieces of evidence you're going to try and put in, if you want to go over that now. I don't care.
Your Honor, I was going to introduce testimony about him working on the 21st and the 22nd. I've got payroll transactions from his work that I think are business records that show that he got paid for that week. And I have some checks.
All right.
Which aren't as clear, and I'm probably not going to introduce those because I can't even see them.
Can your witness testify that she recovered these from his employer and things like that to authenticate?
I have no objections to the 21st and 22nd documents. The check documents I'd like to see, I probably will object to those.
I'm not going to introduce the check.
Okay.
I can't see anything on them, so.
All right. Anything else that you'd like to bring up at this moment?
I have phone records.
That was 3 and 3.1.
But what is the phone record?
We have the silver records so we can.
What'd I do?
Interesting question.
It's not in evidence, so if we wanted to have a phone record and put it into evidence, we'd have to use those.
You can, and we have jointly stated we would introduce a print off. We need to do that. Print off 1,800 pages. But we've already agreed, and it's on the record. You guys can talk about celebrating and close it as much as you want.
So I'm not going to introduce phone records, I don't think. because we've got that celebrate record that says what we need it to say. So that's about it.
No objections to the 21st, 22nd. That's
All
all I'm
right, so we
saying.
need to get the jury back in here, I guess. Oh,
Your Honor, are we making a distinction between the evidence that this was put in by a Val? I have several objections to the laptop, chain of custody, not the least of which.
by Val.
Okay.
Got one in the back.
Okay, all right. All right, jury. Come on in, folks. All right, folks, have a seat. Anything to report? All right, very good. Okay, let's move on.
All right. Ms. Buzz, did you do any investigation into Shelby Shell's employment?
Yes, I did.
And did Mr. Shell work the week of 2/17 to 2/25?
He worked Sundays that week.
He worked on the 20th and the 21st?
Yes, he did.
Were you able to obtain payroll records?
I did obtain payroll records. I would have
Can
to.
Approach?
Mhm.
And is that a record showing Mr. Shell's income for the week of what he got paid on 2/22?
Yes, it is.
Okay. And did you obtain that from Qualcan?
Yes, from
Industry.
Quality Industrial, from the Human Resources Department.
Okay. Your Honor, I'd like to admit this in evidence to Defense Exhibit 4.
This is income of, for what period?
For the 20th and the 21st. The days.
All right, any objection?
No, Your Honor.
All right, this is introduced as a payroll transaction. As defendants exhibit 5.
And Ms. Bronze, I believe that's all the questions I have for now.
All right. Any cross?
Yes, Your Honor. Just a few. Ma'am, were you present here for Ernie Shell's testimony during this trial?
Yes, I was.
Okay. And did he deny on the stand being a deputy sheriff? He denied.
I think he did deny it on the stand.
Okay. Now, the photos that you have spoken about today earlier, do you dispute the fact that anyone who with internet access could have accessed those photographs?
No, sir, I don't dispute that.
Special codes or training or anything of that nature to access those?
No, sir.
Okay. Are you familiar with the term catfished?
Yes.
Could you describe your knowledge of what catfished is?
Catfish, to my knowledge, not that it's correct, but to my
Seems like every
is
time
that
the
someone
prosecution
creates a
talks,
fake
they get to
account and
coughing over there.
portrays to another individual, convincing them that they're someone else when they are in fact not.
I'm going to read you a statement concerning catfish, and would you please let me know if you believe this is an accurate description? A person who sets up a false personal profile on a social networking site for fraudulent or deceptive purposes. Catfishing.
Seems pretty accurate, yes.
I have no further questions.
Thank you.
Any redirect?
No, Your Honor.
No? Is this witness excused? You've been in the courtroom all along. You may sit down, man. You may be recalled out. All right. Anthony? Counsel Pro? What, you have a witness ready out there? Okay.
Let me just make sure he's over there.
Okay, all right. Okay.
You need this TV still out, or you need to put it back on?
There's a call.
The defense calls Cleo Powers, Your Honor.
All right.
I think this might be the Everett's fire chief. I think.
All right.
All right, sir. I'm gonna let you raise your left hand since you're using a cane with your right. You swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Would you have a seat over here and speak loudly into this little black microphone that's on the bench in front over there? And the name again, Miss. What was the name of the witness?
Cleo Powers.
Cleo Powers. Oh.
All right, guys. No judging and no stereotyping.
All right. Go ahead, Miss Karen.
It's good old boy
Mr.
from
Powers,
Everett.
Could you state your name and spell your first name for the clerk, please?
It's Cleto Powers, C-L-E-D-O.
And Mr. Powers, where are you employed?
City of Acres.
Are you a firefighter?
Yes.
Are you the chief?
Yes.
Did you respond to the fire in the scene of Mr. King's death on February 18th, 2013?
Yes.
Do you remember what happened upon your arrival?
Somewhat. I have a fella flagged me down and told me that there's smoke coming from the house. So I went over by there, and sure enough, there was. So I hollered at my officer and got him to page it up. I got the truck, went over there.
And I probably forgot, how did you find out that you needed to respond to a fire?
The gentleman flagged me down.
Did anybody call? Was there a 911 call or that type of thing?
None I know of, other than what I hollered for to have it paged up.
When you arrived, were there people trying to put out the fire?
Not that I can recall of.
If I gave you a chance to look at your report, would that help your memory of what you recall?
It may help.
I may approach, Your Honor.
Okay, what was your question again?
I'd asked him if he remembered if anyone was trying to put out the fire. when we
Oh,
got there.
okay.
We couldn't remember, and there's just a little bit of your report. If you want to read over that, you don't have to read it out loud, just to refresh your memory, and then I'll ask the question again.
Yeah, I speak fluent hillbilly. I am hillbilly through and through.
Did that help?
Yeah.
So I'll ask the same question. When you responded to the fire, were there people trying to put it out when you arrived?
Yes.
Did you know who those people were?
Family members, I'm pretty sure.
What were they trying to use at that time?
A water hose.
And as a firefighter, what was your next step?
When I pull up with the truck, started pulling hoses, pulling supply line, pulling hoses, and members getting geared up to go in. I do know that once they made entry in the home and got it out, I had one guy fall through the floor. And while we was working on checking on him, seeing if he's all right and stuff, one of the other guys, realized he was inside there.
What did you say, the last part?
And while we was dealing with him, that the guy that fell through the floor, some other members realized there was a guy inside the house.
That's the point where you realized that maybe there was somebody who wasn't alive in that.
Yes.
I forgot to ask, did you recognize the guy that flagged you down?
Yeah.
Do you know who it was?
Don't know his name, but I know him.
Did he stick around for the rest of the day, or did you see
No.
him when he took off?
Yeah.
And he wasn't a family member?
No.
Do you remember which firefighter actually first found Mr. King's body?
No.
Do you remember which team members responded to the fire?
Most of them. Yeah.
Can you maybe tell the jury those you remember, and I'll give you a reminder if you don't remember everybody.
I know that myself, Alan Nature, maybe Anthony, maybe Leonard, Tom, probably. Not really for sure exactly who it was, to be honest with you.
But at this point, you don't remember the rest of the people that responded.
No.
If I may approach, again, it's the same.
Okay.
I'm just gonna give you this to refresh your memory.
Yeah. If I remember all of them, I've got short-term memory.
We'll try to get that
Yeah.
on the record. And if I could have some permission to lead this witness, Your Honor, just because.
You can't read his own writing.
Could I have some permission to lead on this, just because it's a short list, and he did remember it, he looked at it, he's been refreshed.
Objection.
Go ahead.
Did Jesse C. report to the scene also?
Yes.
and you're on the list, and, Mr. John Barrett,
Yes.
and Josh Napier.
Yeah.
And Kurt Blevins.
Yeah.
And BJ Guthrie.
Yeah.
And Joey Robertson.
Yeah.
And then some EMS folks, David McGill.
Yeah.
And of course, maybe Everett's PD and KSP Lit.
Yeah. Sure.
About what time do you think you arrived at the scene?
I'm thinking it's early morning. I think maybe around 9ish, 10, something like that.
And when you wrote up, or I'm looking at a report, and I'm not gonna show it to the jury, but you do kind of write up a report of who was there, kind of a log of who showed up that day. When you went into the King home, did somebody open the door for you?
When they made entries, I ain't for sure exactly who opened the door or what. I was at the engine at the time they done that.
And the fire department broke the window on the second floor?
No.
No, you don't think
Family
so?
member did that.
A family member?
Yeah.
And you got there around 9ish.
I'm thinking that's about around time, yeah.
When you're putting out a fire, are you worried about contaminating evidence at the scene?
Well, at the time we didn't know, so we're just doing our normal thing, putting it out.
So you're hosing down everything?
Well, it was a small fire. It didn't do much damage at all. As far as water damage or anything like that, wasn't much of that done.
So it actually was contained to those?
Just that one low area, yeah.
Do your firefighters walk through the scene and walk around and?
Yeah, do the signs, look things over and check things out, yeah.
Those are all the questions that I have for you. I don't know if Mr. Lee has more questions. Thank you.
Ken Cross,
No, you're.
this one is be excused.
Yes, you.
All right. You're free to go, sir.
There you go. All right, go right.
All right, I didn't realize we had it on members only. I want to see if I can change that to subscribers only. That's my bad. If I can change it, I will. Let me bring up the next video first. Bench conference.
We're just waiting on the DOC guy. That's the only person
There's some destruction on I-75 and has slowed them down. So I don't know where they are at this moment. We're waiting for weed. There's some destruction. This is letting.
Or we can talk about jury instructions for a little while they
Right,
go
all
lunch.
right, let's do that, and maybe immediately, there's construction on I-75, and
your last witness.
he slowed them down, all right, so let's break for an early lunch, and we can be working on instructions in the meantime.
Okay.
All right?
We're not taking an early lunch.
And then we can modify them after we get a
Can
final
we
witness,
ask for permission
if
to
necessary.
get some food for the attorneys brought up here? I mean, I pay for it, but, or I'll even send people out to get it. But it takes 45 minutes to go get it, get it back in, and then we can't bring it up from downstairs unless we go out the gate.
I can go get it.
Okay.
You just want to be able to bring it up here and eat?
Yeah, I mean, just
Well, you can do that if you want to.
Okay.
I can go get one if y'all want.
I
If
appreciate
I
it.
go get me and him.
Yeah, just get on with it, and then if she runs out, if Chrissy runs out,
We
gets
can
me
give
something.
them a 2-hour lunch break, so we have some time to work on jury instructions. They need to get our witness here.
Yeah,
They'll
but-
appreciate
We're
it.
gonna take a full 2 hours.
well, I mean,
I don't think we may not take that time, but
Okay.
it doesn't
I'll
hurt
let
to
them
give
go
the jury
for
that
2
time.
hours, and then we need to make sure Weedman gets back here, and we can be working
yeah,
on
well, that
instructions in the
gives us till 1
meantime.
o'clock, and then if that's their last witness, how long do y'all anticipate them being?
10 minutes, yeah, like that,
How long?
that kind of short.
And then we're in
Like Mr.
closing.
Powers, that level of short.
And then we can give it to the jury and let them have it as long as possible. But I'm be prepared, and I'm going to ask if they are still deliberating that we order pizza and we stay here as long
Oh,
as
we
we
will,
can.
we will.
Exactly.
Me too. Good health food, I want it. All right.
Just a second. All right, I'll fix that chat. So what did I do? Uh-oh. Here we go.
All right, ladies and gentlemen, there's one more witness. Unfortunately, there's construction on I-75 and it's slowed up right now. So I'm gonna let you go for an early lunch and be back you have 2 hours for lunch. That's what you can eat for a long time, and be back at 1, and then it looks like that's when we're gonna wrap it up with this last witness. All right. So. Same admonition, of course, don't form any opinions, don't talk to anyone, don't talk among yourselves, and report back to me if anyone approaches. All rise to the jury. All right, we're back on the record this afternoon in the Commonwealth v. Shelby, Shell 13-00-0076, Harlan Circuit Court. Mr. Shell is at the bench right now. If you have a statement.
If you remember, we actually talked about this 1 year.
No.
And we talked about the right to not testify and the right to remain silent in 1 year.
Absolutely.
And we reserved that option until our case, just in case Mr. Shell changed his mind. But we've talked to him about the case and we've gone over kind of the evidence presented and what's going on. And I think right now he's taken the option to remain silent, which is his constitutional right.
Is that correct, Mr. Shell?
Yes, sir.
Thank you, Mr. Shell. All right, very good. Well, let's get on with business then. If you can have a seat there, Mr. Shell.
The record will address the defense had intended to call one more witness, but because he's been advised of his fifth friend, we're not going to call him.
That's fine.
So we'll be
Okay. All right. Well, let's go. All right. We need to call the jury in, please. All right, all rise, Mr. please. Please. Is there anything to report back to me, folks? All right. I hope everybody had a good lunch. All right. Okay, we're still in the defense's case in chief. Where are we at this point? Where are we at this
At
point?
this time, the defense rests.
The defense rests. All right. Is there any rebuttal by the Commonwealth?
No, Your Honor.
All right, then that closes the evidence in this case, ladies and gentlemen. You're going to get a little bit of exercise at this point. I'm going to let you go out again and have another break, and I'll tell you why. We're through with evidence, and so at this point we'll have some motions. Brief motions out of your presence, and we're going to prepare instructions and bring you back in here, and you're going to get the case presented to you. All right. So I'm going to ask you to please step out again, and same admonition as before. Still, don't make up your minds about anything. Leave your notepads there in your chairs and all that, and don't talk about it among yourselves. And report back to me if there's any. So all rise to the jury.
The motions for directed verdict at this time.
still don't make up your minds about it.
I am a newbie. I'm missing some stuff. I've had a couple messages and people can't get on. I don't know what's going on, but I had it accidentally set to members only. It should have been subscribers only. That was my fault.
Okay. All right, be seated, folks.
I'm not sure. Maybe they
All right.
had a feeling this was getting close to the end. Maybe.
At this juncture in the case, does the defense have any matters to bring up at this point?
The defense renews the earlier motions for directed verdict at this time.
Okay,
I don't know that I need to repeat the grounds at this stage.
it's advisable.
It's advisable. So, let me include all of the grounds previously mentioned.
Well, I think I remember the grounds previously made, and again, it's the same standard for directed verdict. We indulge all evidentiary inferences in favor of the Commonwealth, in favor of the non-moving party. I should put it that way. At this juncture, the motion, the only thing that I had a question about earlier was burglary. But as I understand the statute, it's I'm still a little I need some advice on that. And where we stand on that, because it says entering or remaining in a residence or dwelling without consent. Do you have any argument on that particular issue?
I do, and there's another side issue I'll have that argument. So if the court believes or has to believe the testimony of Ernie and Jimbo, if you have to believe Ernie Shell and Jimbo Collins at this stage of the proceeding.
I really can't hear you. I'm sorry.
Can I stand at the podium?
Yes, please do. Please do.
If you have to take what the Commonwealth witnesses said is true at this stage of the proceeding for the drug.
I do, yeah.
And
to.
Ernie Shell and Jimbo Collins stated that Shelby gained entry by pretending to be Kevin and then offered to perform a sex act, and then maybe offered to sell Mr. King a gun. So to the extent that Mr. King did not immediately, upon seeing Shelby instead of Kevin, kick him out of his home or struggle or call police, it appears that there was at least consent for entry at that point. Consent maybe by subterfuge, but consent. So that's why we would make a motion for directed verdict on the burglary first charge.
My concern is,
There are, for example,
it's not the entry, it's the remaining.
right.
I'm not sure about the standard on that, about can they draw an inference from other events that was going on? Can they made the jury draw an inference from the events that were going on otherwise in the house, as the evidence has shown, or has tended to show, that it was without consent to remain there?
And I'll give an example from a burglary third argument, which is somebody might go into Walmart and there's a general consent to the public to come in and shop. But when they become a shoplifter, they haven't committed burglary at that point. They've committed a crime while they were in a place where they had permission to be. Now, if they came back later and Walmart said you're banned from shoplifting, like there have been charges of burglary related to that. This is that type of situation where he, based on the testimony of the Commonwealth witnesses, had the right to be in the place where he was granted access by Mr. King, although he later committed a crime, and certainly would not be granted permission to come back there after that.
Ms. Lee, do you have any response to that? We'll take one subject at a time.
Yes, I've got several responses. So first of all, consent never occurred. Shelby Shell is not Kevin. The evidence evidence of this case shows that Shelby Shell entered Ronnie King's house by stating, "I'm Kevin." Once in there, the evidence shows that it was an extremely uncomfortable situation, and wherein at some point, Shelby Shell removes a firearm. At that point in time, after having gained access by stating that it was Kevin, Ronnie, the victim, Ronnie King, begins to say, "Whatever, I'll do whatever, I'll do whatever," because Shelby Shell has a firearm and is threatening the man. At one point, testimony from the phone call is that he says, "No, Shelby, we're not doing that right now," insinuating to leave. Shelby does not leave and begins to duct tape him, bind him with zip ties, bind him with a belt, do a whole host of other things, and then shoots him in the head. But that's not it. He remains even after that. I mean, Ronnie King can't
I understand all that, but here's my more specific concern is that there's really no evidence that he entered without consent. I mean, the Commonwealth hasn't proven that he entered without consent. That burden of proof is on Commonwealth beyond a reasonable
I
doubt.
think we proved that he entered by stating he was Kevin.
It doesn't, but there's no evidence that he wasn't let in anyway. No
And
matter
then
what.
when the altercations began,
Now, my concern is the remaining, and it's an enter or remaining.
let me ask the court this, Judge.
But let me ask you. My question is: can the jury infer from the subsequent events inside the house that is that sufficient to give it to the jury on remaining without
Absolutely it
consent?
is.
That's what I'm trying to come
And
to
the
terms
point
with.
that I would make more than that, absolutely it is, yes, Judge, but more than that, once Ronnie King is killed, the evidence shows that Shelby Shell remained left, and then what did he do? He came back. The evidence says he came back.
We're getting beyond it. I'm focusing on remaining and the evidence. Does the surrounding evidence after he's in the house, the evidence of him being in the house is presented? Do those subsequent circumstances, is that sufficient to submit it to the jury on remaining?
I would say yes, Your Honor.
That's what I want to know.
Yes. However, my argument would not stop there, because if the court can recall, the evidence that the Commonwealth has submitted is that Shelby Shell got in by Kevin. I'm not making that argument now. Killed Ronnie King, left, and then, as he told two individuals and himself recorded, came back to set a fire to destroy evidence.
I see. Okay.
He couldn't get permission at that point because he'd already killed Ronnie King.
All right. I see what you're saying. All right. Okay. All right. Okay. What about any arguments on the other counts?
On the kidnapping, we would renew our motion that actually this falls into the exemption, that there was no kidnapping in addition to other crimes. There was never a purpose for kidnapping. The purpose, as alleged by the Commonwealth's witnesses, was murder. So the only restraint that occurred was the restraint required for the force to commit the murder. There was no additional restraint to commit kidnapping.
I think the underlying purpose from the evidence is pretty strong. That the underlying purpose was to get his financial gain one way or another, and under Stanford v. Commonwealth 793 Southwest 2nd 112, murder is the ultimate restraint. So the kidnapping exemption does not apply.
Thank you, Your Honor.
All right, so motion Director Burke's overruled. We need to take a break now or go back here and we need to get some instructions together. I have one copy from the Commonwealth I'm going through. I'd like to see what the defense has to offer pretty soon. Okay.
Can we go back there?
And I'll say that murder is well beyond the interference necessary to burglarize or so we'll give you a copy, we got them done already.
I don't have a copy yet.
I'm gonna give it to you.
Okay.
Come on up. Who gives that one? All right. Get the defendant out here. Oh, there he is. Just gonna need to bring the jury in.
Before we do that, I have 2 or 3.
Well, you wanted to tender some instructions and,
Sorry,
for
just
the
for the
record.
record.
right.
The Commonwealth has objected to these, and the court has, I guess, sustained an objection.
The 2 sets of instructions and one having to do with intellectual disability. I'm overruling the intellectual disability, and I'm overruling the 2 sets of instructions because the evidence simply shows nothing more than it doesn't go to theft. It's simply it's robbery or nothing.
Thank you.
All right. So, but put those in the record. It's tentative instructions by the defense. Now we're ready to get the jury in here.
The jury.
They're still here. Oh, well, yeah. Have anything to report, ladies and gentlemen? No. Okay, very good. All right. Be seated, please. We're at the getting ready to give you the instructions and closing. Have our closing arguments. I'll ask the bailiff to hand these out to the jury. So you can all read along as I read you the instructions. Yeah. Okay. Is there anything else before I read the jury the instructions? All right. All right. Let's let all the copies get handed out so you can read along with me, and then we'll leave one copy with. I don't know whether one copy to take back into the jury room with you, because they had the copy that has the verdict forms on it. But I want you to have a copy that you can read along with me while I'm going through these. So I think that's helpful. I'll sign the copy that you take back, and this time we'll choose a form for a person. All right, does everyone have those? Okay. Starting on page 1, these are the instructions to the jury for this phase of the trial. And excuse me. Instruction number 1, reasonable doubt and presumption of innocence. The law presumes the defendant to be innocent of a crime, and the indictment shall not be considered as evidence or having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Instruction number 2, the right to remain silent. Every citizen charged with a crime has the right to remain silent at trial, including the sentencing hearing. This is because it is not the citizen's responsibility to prove that he is innocent of any crime. The law presumes the defendant to be innocent of a crime, and the indictment should not be considered as evidence or having any weight against him. The defendant is not required to testify it says in this phase or in any, as is his right, you shall not draw any inference of the appropriate punishment. Excuse me, that shouldn't even be in there. You should not draw any inference from, and I'm penciling this in, defendants not testify. It's his constitutional right to remain silent. And you shall not allow his choice to prejudice him in any way. Instruction number 3, unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as a foreperson. You may use one of the forms. You shall use one of the forms provided at the end of these instructions. Now, that's a misstatement too. The verdict form is after each instruction, each substantive instruction, and we'll walk through that and you'll see it as we go through. Instruction number 4, these are definitions of certain terms that are in the various instructions. These are statutory definitions of what some of these words mean. Intentionally, a person acts intentionally with respect to a result or to conduct. And his conscious objective is to cause that result or to engage in that conduct. Physical evidence means any article, object, document, record, or other thing of physical substance. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath, including any referee, hearing examiner, commissioner, notary, or other person taking testimony or depositions in such proceedings. Deadly weapon means any weapon from which a shot readily capable of producing death or other serious physical injury may be discharged, including any such weapon that is unloaded or incapable of discharging, so long as it otherwise belongs to a class of weapons satisfying the meaning of a deadly weapon. Physical force means force used upon or directed toward the body of another person. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious and prolonged disfigurement, prolonged impairment of health, or prolonged loss or impairment of the function of any bodily organ, or death. Restrain means to restrict another person's movements in such a manner as to cause a substantial interference with his liberty by moving him from one place to another, or by confining him either in the place where the restriction commences or in any place to which he has been moved without consent. A person is moved or confined without consent when the movement or confinement is accomplished by physical force, intimidation or deception, or by any means, including acquiescence of a victim. If he is under age of 16 years or substantially incapable of appraising or controlling his own behavior, that last part would not apply to this case. That's just a statutory definition. Building, in addition to its ordinary meaning, means any structure, vehicle, watercraft, or aircraft where a person lives, where people assemble for purposes of business, government, education, religion, entertainment, or public transportation. Each unit of a building consists of 2 or more units separately secured or occupied as a separate building. Dangerous instrument means any instrument, including parts of the human body, when a serious physical injury is a direct result of the use of part of that human body, article or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. Physical injury means substantial physical pain or any impairment of physical condition. Wantonly, a person acts wantonly with respect to a result or to a circumstance when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in this situation. There's a bracketed insert there about intoxication, which does not apply to this case. So I'm striking that, and this will be the copy that I will be giving you to consider. Knowingly. A person acts knowingly with respect to conduct or to a circumstance when he is aware that his conduct is of that nature or that the circumstance exists. Possession means to have actual physical possession or otherwise to exercise actual dominion or control over a tangible object. Handgun means any pistol or revolver or any other firearm originally designed to be fired by the use of a single hand. Now, instruction number 6. Murder, a capital offense, count 1. You will find the defendant guilty of murder, a capital offense, if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the finding of the indictment herein, Shelby L. Shell killed Ronnie King by shooting him. And B, that in so doing, Shelby L. Shell caused the death of Ronnie King intentionally. And
Somebody's
C,
phone's ringing.
that he did not act in self-protection. The next page is a verdict form. When I read this in the beginning, it said at the end of the instructions, but the verdict forms for your convenience follow each count. So it begins at the top and with regard to this instruction number 6. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of murder, a capital offense under instruction number 6. You drop down, and there's a place for the foreperson to sign that, and all of your determinations in this matter have to be unanimous. Halfway down the page, next it says, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of murder, a capital offense under instruction number 6. Again, a line for the foreperson to sign. Then you'll see below this, if you do not find the defendant guilty under instruction number 6, then you shall proceed to instruction number 7. However, if you find him guilty under this instruction number 6, then you shall skip instruction number 7. And it will always say on the bottom of the page, foreperson will sign only one verdict on this page. So, instruction number 7 is the following page. First-degree manslaughter. If you do not find the defendant guilty of murder under instruction number 6, you will find the defendant guilty of first-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, on or about February 17, 2013, and before the finding of the indictment herein, he killed Ronnie King by shooting him. And that in doing so, he did not intend to kill Ronnie King, but intended to cause serious physical injury to Ronnie King. And that he was not privileged to act in self-protection. Though otherwise privileged to act in self-protection, the defendant was mistaken in his belief, that he was not privileged to act in self-protection. Or, though otherwise privileged to act in self-protection, the defendant was mistaken in his belief that it was necessary to use physical force against Ronnie King in self-protection, or in his belief in the degree of force to protect himself, and when the defendant and should be stricken, I think. That it was necessary to I'm going to start D all over again. Though otherwise privileged to act in self-protection, the defendant was mistaken in his belief that it was necessary to use physical force against Ronnie King in self-protection, or in his belief in the degree of force necessary to protect himself when the defendant caused serious physical injury to Ronnie King. The and does stay in there, my fault. He was aware of and consciously disregarded a substantial and unjustifiable risk, that he was mistaken in that belief, and that his disregard of that risk constitutes a gross deviation from the standard of care that a reasonable person would have observed in the same situation. Next page again is the verdict form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of first-degree manslaughter under instruction number 7. The second option, the only other option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of first-degree manslaughter under instruction number 7. Again, it doesn't say it on there, but the foreperson should only sign that on that page. Instruction number 8, tampering with physical evidence, count 2. You will find the defendant guilty of tampering with physical evidence if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the filing of the indictment herein, Shelby L. Shell altered, concealed, or removed evidence which he believed was about to be produced or used in an official proceeding by a B, setting fire to the house in an attempt to destroy evidence of a crime, and that he did so with the intent to impair its accuracy or availability in the proceeding. If you find the defendant guilty under this instruction, you will state in your verdict only that you find him guilty. That gets stricken. It takes a long time to do these instructions, and a lot of artifacts get left in there that don't belong in there. I'm marking this out on the copy that's going to be given to you to take back. That's this bottom paragraph that I'm marking out. Next page will be the verdict form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of tampering with physical evidence under instruction number 8. The next choice, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of tampering with physical evidence under instruction number 8. Again, there's only 2 options, and the fourth person shall only sign one of them. Instruction number 9, robbery in the first degree, count 3. You will find the defendant guilty of robbery in the first degree if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the finding of the indictment herein, Shelby L. Shell stole jewelry and money and other items from Ronnie King, identified as Commonwealth's Exhibit 9. And that in the course of so doing, and with intent to accomplish the theft, Shelby L. Shell used or threatened the immediate use of physical force upon Ronnie King, and that when Shelby L. Shell did so, he, Shell, was armed with a pistol. And D, the pistol is defined as a deadly weapon under instruction number 4, which were the definitional instructions. Verdict form is on the following page. We, the jury, by unanimous vote, agree by unanimous vote that Shelby L. Shell is not guilty of robbery in the first degree under instruction number 9. Second option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of robbery in the first degree under instruction number 9. Instruction number 10, next page, kidnapping, a capital offense, count 4. You will find the defendant guilty of kidnapping if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the finding of the indictment herein, Shelby L. Shell restrained Ronnie King by wrapping zip ties to the hands of Ronnie King, or by wrapping duct tape around the hands of Ronnie King, or by wrapping duct tape around the head of Ronnie King, and that the restraint was without Ronnie King's consent, and that in so restraining Ronnie King, it was Shelby L. Shell's intention to accomplish or advance the commission of a felony, and that Ronnie King suffered a serious physical injury during the kidnapping. Next page is the jury form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of kidnapping, a capital offense, under instruction number 10. Next option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of kidnapping, a capital offense, under instruction number 10. Again, with lines for 4 persons to sign one of those decisions. Instruction number 11, burglary in the first degree, count 5. You will find the defendant guilty of burglary in the first degree if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the finding of the indictment herein, Shelby L. Shell knowingly entered or remained in a building owned by Ronnie King without the permission of Ronnie King, or any other person authorized to give such permission. That in doing so, Shelby L. Shell knew he did not have such permission. C, that Shelby L. Shell did so with the intention of committing a crime therein, and D, that when effecting entry or while in the building, Shelby L. Shell was armed with a pistol defined as a deadly weapon under instruction number 4. Next page is the verdict form. Again, we, the jury, by unanimous vote, find that Shelby L. Shell is not guilty of burglary in the first degree, or we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of burglary in the first degree under instruction number 11. Next page, instruction number 12, arson in the second degree, count 6. You will find the defendant guilty of arson in the second degree if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Harlan County, Kentucky, on or about the 17th day of February 2013 and before the filing of the indictment herein, Shelby L. Shell damaged a building owned by Ronnie King by fire. B, that Shelby L. Shell started the fire intentionally. And C, that in doing so, it was Shelby L. Shell's intention to damage or destroy the building. And D, that Ronnie King did not consent to the damage to the building. And E, in doing so, it was not Shelby L. Shell's sole intent to damage or destroy the building for a lawful purpose. Finally, the next page is the verdict form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of arson in the second degree under instruction 12. And we, the jury, the other option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of arson in the second degree under instruction number 12. Again, the full person will sign on number 1. When you get through those instructions, you will tell the bailiff that you are ready to return your verdict to the court. The bailiff will be outside the door at all times, and we will come in and you will deliver your verdict at that time. Now, I'll go ahead and say this now. You may take your notes back to, we're going to have closing arguments in a moment. You may take your notes back to the jury room with you, but they are not in any way to overrule the memories of the other jurors or your memory. It's your memories that count, all right? And at the end of the trial, we'll take up the pads from you. Now, before we...
Can I approach real quick?
Sure.
He gets so frustrated with that guy. Your Honor, may I approach real quick? Oh, he's complaining about the cops.
I just want to put on the record that there's a heavy police presence here. There's 12 cops here. If the court would, maybe tell the jury that the people that are standing there are there to protect and make sure that the room is secure. I mean, I don't know. I don't know why we have so many police here. But
The Commonwealth didn't invite them. I don't know.
Probably spectators.
and the fact that they're back behind, I think causes some prejudice, and I just want to put that on the record.
Well, this is an open courtroom. It's free and open to the public. If they ask.
They've been here the whole time.
No.
Well, it may have. I don't know. I'll just tell them not to be swayed. All right. Okay. We pick the officers now, or we want to do your arguments first? I guess
I think we do the arguments.
Yeah. Okay. All right. All right. Okay. Ladies and gentlemen, there's several law enforcement people around. Don't let that sway you in any way. I think perhaps a lot of people wandered in to observe the trial. So please don't be any of your decision making be swayed in that by any of that. Now, the the instructions I just read to you are going to be the ones you're going by, because I made a few little notes to change it. And at the end of the instructions, I'm going to go ahead and sign them and date them right now. And they will be the instructions the court has indeed, in fact, and officially given to the jury for their deliberation in this phase. Let's see. All right. So what I'm going to do at this point is, during closing, you can refer to your instructions, because I think counsel will probably refer to them during the closing arguments, and then we'll take them up before you deliberate. And I'll give you this one, give the bailiff this one for you to take back with you. And when you get back there, you'll select a foreperson and begin your deliberations. All right. Mr. Simon?
I'm gonna run yellow, so we will need to hold this together. I don't know how to turn that on.
It's on.
That's ready.
Should be here. It looks like a little tape.
This seems out.
I'm gonna wanna refer to some of the exhibits. I don't believe it's.
They're over to the left.
Yeah. I wrote down, it's exhibit 1 and maybe exhibit 2.
Your exhibit.
Yeah, 1 and 2. I don't need them, but I need them to be able to do that.
you guys have exhibit 3?
Commonwealth's exhibit 3, no change. Think with pictures, I think she married. Yes.
I think that's just for
Really important day. There couldn't be anything more serious. I asked you to keep an open mind and to keep wondering what was coming next. And now I'm going to ask you to worry over the evidence and pay attention to the things that did and did not come into proof in this trial. I think it's always good to give the benefit to the most neutral witnesses first. And again, this was a crime that was committed, and you can't say that it didn't happen. It's very clear that somebody murdered Rodney King. And the medical examiner wasn't here to testify in person, but we were able to play the video of her speaking over the phone, and she did provide written reports. So the first thing I'd like to talk about is the time of death, and whether Mr. King was even killed on February 17th. I'm gonna ask Will to put on the Elmo. Start with page 4 if you would. And I've got a lot to go through, so please be patient with me. There's a lot to go through. You all have sat through a lot of evidence. On page 4, one thing that you'll see here, and I guess you can use your pen too. On February 19th at 8:20 a.m., let me say that for the record. On February 19th at 8:20 a.m., Dr. Kushimoff did her autopsy. And she could not give a specific time of death. She could only say that he likely died in the past 24 hours. She didn't test eye fluid or vitreous humor, and she had some explanations for why that might not really help with narrowing down a time of death. But basically, she couldn't pinpoint a time of death. If you could pull up page 7 of that report, just on page 7, in the external examination of the tracheobronchial tree reveals minimal granular black material. Say that over here closer to the microphone. Examination of the tracheobronchial tree reveals minimal granular black material. And I think when she was asked what that was by Mr. Boggs in her testimony, she said soot. So Mr. King had soot in his trachea. That means that he likely died within minutes of inhaling smoke or soot from a fire. I believe it's on page 1, but it may be further down the page here. Yeah, part 3B. Post-mortem heart blood carbon monoxide. That's gonna say less than 5%. And Dr. Rolfe testified in part about maybe the color of the blood, but basically some amount of carbon monoxide is caused from inhaling smoke. And so Mr. King did not live long enough to have a high level of carbon monoxide in his bloodstream. But he did live long enough to inhale some smoke from the fire. So while we cannot pinpoint, and there is no evidence pinpointing a specific time of death, there are indications that he died after the fire was set. And those are medical results, scientific results. You don't have to rely on somebody's memory or somebody's story. That's just science. Let me add, there is a certificate of death from Coroner Bianchi. I think that has a page number as part of collective comments at the file, I believe. Just to be clear, this 11:50 a.m. is about 2 minutes after Coroner Bianchi arrived. I'm going to point to the brain injury in minutes. Then I'm going to get closer to the microphone again, I'm sorry. But pronounced dead February 18th at 11:50 a.m. That is not the time of death. That is when Coroner Bianchi was first able to say he's deceased. But this second part, brain injury and gunshot wound to the head, that little box to the right here, that's labeled the approximate interval between onset and death. Let me say that again. Approximate interval between onset and death. That is that brain injury, that gunshot wound, minutes before he died. So this wasn't something where he struggled for hours or laid in flames suffering. However, he was shot in the head, died within minutes, and inhaled some soot or smoke from the fire. He was examined head to toe. Dr. Rolfe confirmed that. He didn't have any head injuries. He didn't have any injuries other than a couple scraped knees. That may be consistent with the sex act that he was expecting from somebody who tried to get into his home, or it may have been from something completely different. We don't know. But what we do know is there are no other signs of struggle on his body. So I'm going to get over to Garrison and Gabbard a little bit, talk about the fire. The bearded guy, Mr. Garrison, talked to all of us about the arson. Said that there were at least 2 fluids used, 2 different ignitable fluids, and there were 4 different spots where a fire started. And Gabbard had testified earlier that he didn't think there was an accelerant at the time, but then of course the lab came by and tested the ash and figured out that there were 2 different forms of ignitable fluid used. To me, that sounds like a 2-person job. I can only represent Shelby Shell today. Not representing any of the other people that appeared or might be charged later. But I don't dispute that this was an arson. What they explained makes sense. They couldn't give you a time that the fire started, but they could talk about how the oxygen in the home gets used up and the fire starts to put itself out. So that again gives us an idea that when they responded to the fire, it couldn't have been very long after it started because it was beginning to put itself out. I don't need the picture of the home, although you're free to review that when you go back and you're looking at the evidence. They knew
Now back now.
details about this scene that no one else knew, that Detective Courtnett kept close to his chest, right? This was not a secret investigation. This was the talk of the town. By 11 o'clock, there were crowds, and you will see in the Everett's funeral home video that's available to you to review. You saw portions of it during the trial. There were crowds of people coming out to see what was going on. And they had access to this scene, and these firefighters tromped all through the house, and things that might have been collected were damaged, destroyed, or not collected. But importantly, these folks were there. They knew facts about this investigation that people outside of firefighting and law enforcement might not know. And that's going to be more important as I keep talking.
Ms. Karen, I'm sorry to interrupt you. I was glancing back. I found a mistake in the instructions. Would you turn to page 13, please?
They're at the bottom of that stand.
Are you there? It's kidnapping count 10. Go down to G. He should say that it says Ronnie King suffered serious physical injury. It should say that Ronnie King was not released alive. And that coordinates with the jury verdict form and the indictments. All right, so I'm going to change that on mine, and that'll be the one that'll be given to you. All right. Go ahead, Mr. Graham. I apologize. It's been a busy and difficult day, and you all have been a big help, and things get by stuff.
In addition to people who should have been there, Mr. Powers also mentioned some guy who flagged him down and disappeared. I'm gonna ask Will to put up a photo in the yellow of a man walking away from the crime scene. Yeah. Nobody's talked about this man. Detective Courtnett mentioned something about a lone figure on the tracks, and I have trouble seeing that in this video, but he had the option to zoom in. But we don't have names for that lone figure. I'm sure if that had been Shelby Shaw, he would have told you that, right? So we have an unidentified lone figure coming down the tracks. We have an unidentified gentleman in a hoodie leaving, maybe not at 1:18 because the time's not perfect on here, but sometime in the afternoon, leaving the scene of the crime. We can take that picture down. I'm gonna move next into Mr. Rogers, the phone records custodian. Again, somebody who's not on the scene or trying to tell a story, he's just pulling data from the phone. If we could first use the small printout about which phone numbers go with who. Okay. You'll see on this account number for James Collins. His main phone number is 606-309-0460.
And in the phone records, it will be labeled as James or Jimbo. Pull that up. The second number that's highlighted, 606-515-7122, that's the number that Mr. Collins said was his daughter Sarah's and that Ernie was using at the time. And Jimbo was paying for that phone.
Of course, I pay for my phone. It's my daughter's
Leave
phone.
that up there for a minute, but I think you're gonna need the celebrate reports. Okay, go ahead.
I still pay for it.
The next record I'm gonna show you is a portion of the Celebrate report that Mr. Rogers pulled from Chevy Shell's cell phone. Not that one, the one with the blue label, sorry.
Which one?
The one, just take that off of it. The one with the blue heading says Celebrate report,
Oh, gotcha.
or it says forensic examination or something. Okay, so this is the extraction report. If you'll flip, I think just this first page, second page. I think it's the third page. There, okay. What's interesting about this report is that the red indicates things that were deleted. And you'll see as we go to a couple of pages, things that were deleted are in the report. They didn't disappear forever. They're part of what they could get. If you'll flip to this first tab that says lead.
It says Lee.
So Mr. Rogers' report was very large. I think Detective Cornett said something like, well, I tried to look through it. Because it's like 1,800 pages. It's a lot to look through. And one of the things that Detective Cornett didn't do was he didn't try to find out if what Shelby told Y&T was true. Like, he arrested him within hours of the story from Ernie and Jimbo, and that was that. So this call, you might need to zoom it out a little bit or just move it over. These are actually texts. Again, you can't really record people's phone calls with these data dumps, but this is February 10th. Where this is Shelby texting Lee, his boss. They mentioned Lee, I think Detective Porter talked to Lee. Lee, this is Shelby. I went and picked up my check Friday. Your dad said y'all would give me another chance. I won't be late or miss or let you down again. Do you need me to come in tomorrow? Really, man, I'm sorry. I need it bad. I have a family to feed. So that's just a demonstration that Shelby was employed. He was still begging for a job. And again, later on February 10th, thanks man, you're welcome. Like Lee was still letting him come in and work. If you'll kind of go back to the next lead tab, I think there's one from the 21st.
On the 21st.
Because Shelby shared this phone with his wife, there are some things in here that have nothing to do with this case, so we're not going through every single message. I should have a tab that I'm able to get to it. Okay. So this is February 21st, 2013, in the evening. And I'm going to read it out loud because I think he's probably talking into the phone. It says, leave, which means leave. This is Shelby. I was wondering what's going to work tomorrow and what time you want me to come in. Thank you. What time do you want me to come in tomorrow, Lee? This is Shelby Shell. And Lee responds 8 a.m. So he was still working. He had some trouble. But on the 21st, he went to work. On the 22nd, he went to work. And you heard that from Jessica Wells here towards the end of the trial. I think the next tab is going to cover a portion of the 17th. It may be pink. I mean, look it in. Yeah. Right.
17th, yeah.
Yeah. Okay.
I need to see
If you
that.
can slide it over so they can see the numbers a little bit. I want to see the tabs, I want to see the numbers on the side. Okay.
Okay.
Yeah. Okay, so. This is the 17th at, say, 2 a.m. This is texting Kiefer, who's the son of
Shelby's wife. Just like, are you still at Kobe's? Where are you? Okay, if you're too tired to drive, no, I'm leaving. Call the Jimbo, like, hey, pick up your phone, bro. It's Jimbo's number, but it's actually bro, it's too early.
Yeah.
And then at 12.
Men don't ever call each other bro unless they're
about,
brothers.
Let's see, 3 p.m. These are mid-afternoon calls or texts. At 10 p.m., I smell something burning is texted to Keeper. At 12:37, hey, use my card to get food. I don't know about you, but if you know teenagers, they communicate by text. So give me the next room and you're texting them. If I say, are you cooking? I smell something burning. That usually means I'm in the same house as you. Texting my teenager. So this is just a record that there was a text from Shelby Shell to Keeper on February 17th at 10 p.m. and again at 12:37 a.m. If you could pull that for a second and put up the Google
it.
This is the Google map that we've shown council, I think, for Berea. But this is Berea, and this is Everett's. What is it, 2 hours and 13 minutes, 124 miles. So you can't go from 10 to 12 and get to Everett's and back. So from 10 to 12, at least, really the whole night of the 17th. Shelby Shell was at home into the morning of the 18th. He could not have, left and come down and gone back and done all these things that Ernie and Jimbo say he did. If you were to take that map back down, I just need to see if there are calls.
Other calls?
Can we get through all the tabs?
No, just over.
I'm gonna do peach ones.
Okay.
And then this one that says wine peach, so hit that. And we're just going through the phone records that Mr. Rogers pulled. That's sort of the section. This is just text between Shelby and Ernie on the 24th. Just to demonstrate that he continued talking to his brother multiple days over that whole week. If you'll flip to the next PG tab. Oops, that's okay. And pull it up a little towards where the tab, this paragraph. You heard Shelby Shell talk in the Line T video a little bit about what Detective Cornett talked to him about when he interviewed him when he was arrested. And he said he'd just been talking to Ernie, and that he said something about 30 minutes, and basically he went over this conversation, and Detective Cornett never, went after his phone to see if he actually had that conversation. So for Ernie, because they were ready to arrest Shelby and they wanted to believe Ernie, they talked to Trooper Cottle immediately. They said, "Oh, he went through a roadblock, he must be telling the truth." For Shelby, they get his phone records with a search warrant 3 years later. They don't go through all 1,800 pages. And it turns out what he said is what he said. He said, "Ernie, I got some gas money for you with the car up and gas to fill it up when you go home, and I love you, and when you get ready, I'm ready. I was like across the street here and bought some shoes and stuff and clothes, and I love you more than you by everything in life, for the air that I breathe, I love you." That one actually went just like I love you, man. This is the best way ever. Got along. He said got alone, which I think this is the best we've ever gotten along. But he was speaking into the phone. "I will always love you. You, my brother. I love you, bro. Thanks for being there for me. You and Sandy." And then pick the phone up, talk. She's not going to answer the phone now. We'll just call Jim, pick the phone up. And then, "What's up, man?" And then, "Ernie, I can't talk right now. Cindy's sick. I'll call you in 13 minutes. Let me get away from her." His wife messages, is he on his way? Okay, cool. Because they were getting ready for that, they had gotten together, they were being social. But the things that he said in text. That's all I have from that phone report for Mr. Rogers. I don't doubt Ms. Copeland that there was a gunshot through a pillow. I think Ms. Mulkey, Ronnie's sister, said that he said Dixon's here. And that almost every other part of the trial, Ernie or Jimbo said Kevin's here. And she was very insistent that Ronnie said Dixon, and that she thought that meant Kevin Dixon. And that was around 8 p.m. on the 17th. All that being said, Detective Cornett looked into Kevin Dixon. Of course, Kevin didn't come into court and speak to you all. His girlfriend was deceased. She didn't come into court and speak to you all. The cashier from Marathon didn't come into court and speak to you all. There's no video from that marathon. I didn't collect that either. But it sounded like they believed he was where he said he was from about 3 p.m. to about 6:30. That doesn't cover after 10:30 to 8, 9 in the morning, to 11 in the morning, any of the early hours of the morning. And Kevin lives in Everett. Kevin was minutes away from Ronnie King's house. The idea that nothing that was taken from him was tested and that he's not sitting at that table today is ridiculous. Jesse said he suspected Kevin stole from Ronnie King in his last break-in and stole 300 big lighters, even though he was friends with Ronnie and went to the store with him. One of the Farleys, Shannon Thompson, who's Ronnie's niece, I think Jerry, said they saw Kevin Dixon's vehicle at Ronnie King's home after 8 p.m. on the 17th. Those folks I don't think are making up stories. I think they're telling you the truth. Now, obviously, I think Ernie and Jimbo are making up stories. Pam came in and said Ernie's a liar and friends with Jimbo, threatened her. Lucinda came in and said Ernie's a liar. John Paul Madden came in and said Ernie's a liar. Amber Madden came in and said Ernie's a liar. John Paul said Ernie and Jimbo kissed in his driveway. The whole premise of the story that they told to Detective Cornett was that somebody was offering Mr. King a sex act to get into his home. And then Ernie denied being gay and has a profile on a gay website. And yes, there's a thing called catfishing and fake profiles. But you combine that with Ernie being in a relationship or friends with Jimbo for 15 years and kissing him in front of John Paul. And the other things that Ernie said that weren't exactly on the up and up. And I think it's pretty clear that he's gay, or at least bisexual. And it was pretty easy for him to think of that as a story for how to get into Ernie King's house, even if it didn't happen. I think the Commonwealth said zip ties, 100 times. There are some zip ties in those photos. There's a zip tie on the left wrist. We're not going to show it, but on the left wrist of Mr. King. There were zip ties on the floor that Mr. Bianchi caught in his photos, but Detective Cornett didn't collect or have tested for body fluids or DNA. Zip ties are one of those things that you see on TV in shows like Dog the Bounty Hunter, that you see in TV on Law & Order or CSI. Zip ties are something people use if they're fugitive recovery agents. To me, zip ties are the type of thing that Ernie Shell would use, and not the type of thing that would tie Shelby Shell to this event. Ernie and Jimbo went to Marvin Lidford first. Ernie said he searched on the internet about details of this case, and then when he had enough details to present a story, he called up Marvin. He didn't go directly to KSP. Just have to wonder, he was thinking there. You might not have to wonder too hard because he did admit that he's writing a book. And he may have known that Marvin was working on a reality TV show, went to him first. But the fact is, he had time with another law enforcement agent and with his friend Jimbo in advance of actually meeting with Detective Gordon. They had time to get their story straight. So sure, they were interviewed separately and it all matched perfectly because they worked on it before they got there. You heard from Jessica Wells that Ernie and Jimbo and Kevin are all friends on Facebook. I'm moving away from the people who are neutral witnesses and the lab reports and start talking a little bit more about Ernie and Jimbo. Jimbo knew Ernie for 15 years. He claims he has full disability since 2008, but he's also a wrestling promoter. So he's got full kissed Ernie. Ernie was using his cell phone, and Jimbo was paying for Ernie's cell phone. And Jimbo's story matched Ernie's story completely, including things that were wrong, which I'll get into later. And Shelby borrowed $70 from Jimbo and hadn't paid him back. So he wasn't real happy with Shelby. The outlandish claim of killing 9 people, Jimbo reported and said, well, I thought he was joking. But he didn't think he was joking about this, which is strange because Ernie, Shelby, Jimbo all seem to have a little bit of a sick sense of humor. Jimbo's home got burned down, interestingly. He was in the process of moving into a new place right about when this happened. So Ernie's interest in face masks and horror conventions, his label as the killer inside, tends to lend itself to sort of a sick sense of humor. So it's quite possible that, not possible, it's what happened is that Ernie and Jimbo talked with Shelby about some of the details of this case and convinced him that he was playing a joke on Ernie when he called Jimbo. But Ernie, even without that, is just a liar. He's researched things on the internet. There's a specific part that he went through where he said that the bookshelf got knocked over. And so there's a picture here from Corner Bianchi. And we'll put that up again. Big deal about it. Got in a real tussle and Shelby threw the bookshelf to the floor to look for this money, and yada, yada, yada. And here's the bookshelf. Also, there's a window with no blinds. So that story about coming back to take fingerprints off blinds, that story about knocking over the bookshelf and going through everything to find some money, that's just not true. Like, you can see for your own selves with your own 2 eyes. That is not true. Ernie said, and Jimbo said, because they have the same story.
No, it wasn't the same exact story.
And
No.
came back. And the medical examiner evidence
Both
is
did
very
say that.
clear. That Mr. King died at the same time that there was a fire going on. And he died within minutes. That's not enough time to drive to Burglary and back for sure. That's not really enough time to drive up the road a half hour, turn around and come back. It didn't happen. There's no way that somebody left and came back and started the fire separately. The person that killed Ronnie King shot him as a fire was already going. That's what the medical examiner's evidence shows. Ernie lied when he said Shelby cleaned up the blood. You'll see in those same photos, which you'll have to look over at the back. Nobody cleaned up any blood. There's a pool of blood. It is still wet when the coroner gets there.
So why would Ernie lie about that? I mean, if Ernie was the one who did it and set Shelby
He
up,
said
why wouldn't he
Shelby
tell him
got
what really
blood on
happened
his shoes,
and then say Shelby
which
did it?
also apparently were Ernie's shoes. No footprints, no blood dragged around, no blood spatter. Detective Corden said that on the stand. Said Shelby got blood on his pants. Again, no blood dripped anywhere. And they certainly didn't try to collect any shoes or clothing, like pants from Shelby. Ernie says they spent all day together around the 24th and went through a roadblock, and he did go through a roadblock. But he also spent all day together with Ernie the day before he turned him into the police. He went through a roadblock and didn't tell the police, I'm in a car with a murderer. He had all week to call the police if, in fact, Shelby had told him that he killed Ronnie King before the 25th. But he didn't do that. He went to Marvin first because he's writing a book. Of course, he is claimed to be a professional boxer, a fugitive recovery agent, a bounty hunter, a bondsman, and he's not actually licensed or clearly actively licensed in any of those fields. That's Ernie and Jimbo. I think it's important to go back to Jesse Farley a little bit, because he said that Ronnie kept old coins, including mine script, and the jar of wheat pennies that is in evidence apparently had at least one mine script coin in it. There were also old coin wrappers that appear to be like for quarters in the photos and evidence. He also said that Ronnie was like an unofficial pawnbroker. People brought stuff to him, he kept it, gave him some money, and then got it back. Every one of those unofficial pawn customers is a potential suspect. Anybody who owed Ronnie King money is somebody who had a motive to kill him. Kevin is a suspect because he allegedly stole from Ronnie King. But that list could be much longer. Part of Ernie and Jimbo, or at least Ernie and Shelby hanging out all day on the 24th, is that when they went to arrest Shelby, they didn't find things in his house. They found things in his home. They found things in his truck. And who was driving his truck the day before? Ernie. Ernie was driving his truck around. And those coins that may have been Mr. King's were in that truck.
Except for he tried to sell them to me a few days earlier.
And there's a specific mention of a Kentucky cluster ring, which is like a round ring. That's, my experience with those, they're like round cluster. That's not the ring in the jewelry. I don't know where that came from. But I know it's not evidence that Shelby Shell robbed and killed Mr. King. It's just not. So I'm going to go through the investigation. I think the Commonwealth called this a sloppy killing, and I would call it a sloppy investigation.
I agree with both.
Detective Cornick got a phone call at like 10:50 in the morning. He got there by 11:56. He said he kept a crime log. You're not going to see a crime log in the evidence. There's not a crime log. He got there an hour after his call. He got there probably almost a couple hours after people noticed the fire. Tons of people walked through that scene. Everybody with the fire department. There's no log of those folks. He didn't personally interview Kevin. He didn't request testing of the things taken from Kevin. He didn't even keep the second pillow that Mr. King was on. And there's this thing called mixed samples, which is to say, like, you could have a lot of blood that you think is from the victim and still collect it because there may be blood from a suspect in there. And they can do testing for mixed samples. So to say that there was so much blood from the victim on earth that they didn't need it or didn't have value is just incorrect. He didn't collect the zip ties that seem like such a big deal now that we're at trial. He didn't collect a blood sample, even though the blood was still wet. He didn't collect bullets from anywhere other than those collected during the autopsy. He didn't collect Ernie's information. He didn't collect or any items from his car, search his car. He didn't collect the metal file that Shelby was supposed to have used to file down the gun. He didn't collect Jimbo's fingerprints or information. He didn't collect.
I've been arrested in Harlem. My fingerprints are on file,
He
honey.
didn't collect the marathon video for Kevin. He didn't collect Ronnie King's phone, Ernie's phone, Jimbo's phone. Didn't request cell tower records or phone records from any of those phones. Took 3 years to get a search warrant for Shelby's phone. He didn't request testing of fingernail clippings that are listed in the autopsy report. Fingernail clippings are often used to gather DNA in case people have defensive wounds. So somebody who fights back or scratches their attacker may very well get cells under their fingernails. That's why they clip them and usually have them tested for DNA. But this is a case where there's a sample of DNA that is not Shelby Shell's. And then there's no DNA because
Hope
things
people
were
are paying
tested.
attention to that.
And there's no murder weapon. You know, frankly, that would be helpful to have. A murder weapon lets you know, did somebody leave fingerprints on it? Did the serial number go back to someone who, if they're not the suspect, can tell you who took their gun or stole their gun or who they sold their gun to? No murder weapon. We don't have that. They didn't collect any fingerprints from any blinds because there's no blinds. They didn't check into the alibis for Ernie or Jimbo. Didn't check into Kevin Dixon's alibi after 10/26 on the 17th. No crime log. They didn't do an internet search for people talking about the crime on topics. They didn't thoroughly investigate Shelby's story. They didn't talk, he offered DNA. His DNA doesn't match the samples that they took. He offered fingerprints. They said there were no fingerprints to compare to. They didn't speak with Amanda or any of the females that Shelby had mentioned Ernie being jealous about. They didn't look at his text messages. What they did collect that, I'll pause and talk about that journey a little bit. The journey that Mr. Rogers pulled from the Cellbrite report, that's like asking for directions. Yeah, apparently somebody asked for directions on that phone. We don't know if it was Shelby or Ernie or somebody else living with Shelby who had access to his phone. But what we do know is that's not a map of where he drove.
So now we're
That
blaming
doesn't tell
Ernie
us where he
for
was. I think
Shelby's
the phone
Google
records
searches.
that I pointed to earlier, where he's texting Kiefer at 10 in the evening, 12 in the evening.
Hey, no, that wasn't Ernie texting Kiefer at
That
12
kind
in
of
the
tells you
evening.
where he is, but they don't have anything to say that he actually drove that route. Kind of like the looking up melting gold. Like, it doesn't have anything to do with where he was on the night or early morning when Mr. King was killed. They did collect the funeral home video from Everett's, and I'm not going to replay that whole thing, but as we were watching it earlier, the first few seconds, look for a Dodge Caliber, the car that Lucinda said Ernie was driving, her car. Look for that smoke flare around 9-ish in the morning because the time's on that right on the board. And think about how close in time what appears to be a Dodge Caliber driving up Kelly Street.
That's dirty right there.
Is to the plume of smoke coming from the house. So I don't want to miss anything that's really important because this is really important. So I may be repetitive, but the story I heard and the story that I wanted to tell are not exactly the same, but they're pretty close. The story I heard was that a couple of guys, Ernie and Jimbo, and their long windy tail, convinced Detective Cornett that he needed to go arrest Shelby Shell. But then as evidence came in, as his DNA didn't match, as they didn't collect phone records, as things came in, they didn't change their investigation at all. It's not like he went, oh, there's stuff on the internet, I'll go look at those people. Or there's a man walking across the parking lot, I'll go see who that is. He didn't do these 5 fingers of investigation. Within hours, he arrested Shelby Shell, and that was the end of his case. It took him 3 years to even look at his phone. So, when you go back and elect the foreperson, you're gonna look at the instructions. You're gonna reread that part about he's innocent and they have to prove his guilt beyond a reasonable doubt. And the jury verdict needs to be unanimous. So if you have a strong belief after you've looked at the evidence, you can't be bullied into changing that. It's not voting to vote with the team. Any individual person can hold out and stand for what they think was actually proven in this case. So look at those instructions, order some pizza, look at the evidence, look at everything that is missing from the evidence, review anything you like. You can re-review any video that's in evidence, any document, any photo. And let's go over the jury instructions just for a moment.
Mr. Chairman, as you reviewed them, I hope, recall that I made some changes as I was reading them to the jury, the mistakes commonly come up.
I think we made all the same corrections.
Okay, great.
It's important to me that you watch the YMT video, and I think you can tell from that video that Shelby Shell is not the most intelligent person, just by his pattern of speech and the way he remembers and tries to put things together chronologically. So that statement to Jimbo with wrong facts was part of a sick joke. But if for some reason you believe Ernie and Jimbo, then I do also need you to remember that Rhonda King supposedly shot first. And that's part of the instructions in instruction number 6 and instruction number 7. So what I'm hoping you do when you go back there is understand that Shelby Shell didn't kill Rhonda King. They're not guilty on that murder. And I'm hoping that you say not guilty of first-degree manslaughter as well. But if for some reason you believe Ernie and Jimbo, then I think if you believe that, you would have to choose the first-degree manslaughter over the murder. Because even if he was mistaken, if he was shot at first, then he had at least mistaken that he could defend himself. But really the most important thing for each of these instructions is to flip over to the verdict form and sign the not guilty line. There are so many holes in this case. And I told you were likely to hear a tape statement from Shelby Shell. And the stories from Ernie and the stories from Jimbo. And even those stories, matchy as they may be, are wrong. Nobody left and came back and started a fire. We know that from the medical examiner. Nobody knocked over a bookcase. We can see that in the photos. There's no blinds on the window. There's no footsteps through the blood. There are just, I've got pages of things that Detective Cordet didn't do, didn't collect, didn't test, didn't follow up with other leads. They sold him a long-winded story, and his investigation stopped. And that doesn't provide justice for Mr. King, and that doesn't provide justice for Shelby Shell. But at the end of this trial, you could find Shelby Shell not guilty, and that would be justice. Thank you.
Thank you, Mr. Chairman. Please.
We may have our I need to have people at the Elmo responsible.
Yeah.
Sure, all right. Report.
I've, what the exhibits were using. With pictures.
May it please the court,
Yes, sir.
Ms. Karen, Mr. Simon, ladies and gentlemen of the jury. I was not here for opening statements, but you've seen me here since that point in time. And I want to introduce myself and Jonathan Lee, Assistant Complex Attorney. But what I want to talk to you about right now is, I'll start with one of the things that Ms. Karen said in her closing, and that is that this is very important. And it certainly is. Life and death. Life and death. That's how important this is. The life of Ronnie King and the death of Ronnie King. And not just a death, but a murder. And a horrible, horrible murder at that. Now, when Ms. Karen and I are speaking in closing arguments, that's what it is, it's argument. And we're only supposed to talk about stuff that actually came in as evidence, either through testimony or a piece of tangible evidence, and certain things that you can infer. That's all we're supposed to talk about. So I want to talk to you about some of the things that were said. You know, one of the things that was talked about by Ms. Karen was that we don't know if it even occurred on the 17th, if the murder of Ronnie King even occurred
I'm gonna object.
on the
and ask the
17th.
Objection, Your Honor.
Come on. Come on.
I'm not saying you can never say anything about what I said, but I think I need to ask it before we start telling the jury it. So what do you think?
But you said that you don't even know if it occurred on the 17th, and the instructions say on or about.
Yes, they do, on or about.
That's what the
I have the
indictment
exact
says.
information, if I can see that argument.
Okay.
Okay. But I didn't say anything.
You said
incorrect,
exactly, we don't even know if he was killed on the 17th, and I'm going to say it doesn't matter because it's on or about.
right? Okay, but I didn't say anything incorrect. I didn't misconstrue evidence.
Well,
You made it sound like I was misconstruing evidence.
Actually, I'm going to get to what I do think he misconstrued, and that is that the medical records, nowhere in there does it say that he was alive. It says minimal soot. In fact, when I asked, she said, I can't tell you whether or not he was alive.
You guys hearing
That's
that?
an inference that someone
I
could
can't
draw
tell
from
you.
those records.
I can't tell you whether or not he was alive. So I'm going to
So
talk
that's not
about
an
all of that, and I'm permitted to do that.
I don't want him to characterize what I said as misinterpreting or misconstruing evidence. It's evidence with a different interpretation of the evidence.
Are you representing the jury that it did not, his death did not occur?
No, it's in the report. What I'm saying is I may have a different interpretation. He has a different interpretation, but I don't want him to say that
Wait a minute.
that it was a,
Are you representing the jury that it did not occur on the 18th? Just tell me.
that is part of the defense. Is that it did not occur on the 17th, it occurred on the 18th. But that's still on or about.
It says on or about, which is what I'm gonna say.
Yeah, I don't think it's
First
outside.
off, when she says inference, the only thing that I've said thus far is that both of us have to only say things that actually came in as admissible evidence. That's not a false statement. It's not a misleading statement. It's 100% true. And
It's an implication that I
both
said
held to
something that
that
wasn't
standard.
evidence, which is
What
not
did
true.
you say?
I said that if you interpret the medical examiner's results,
That's not what
you
Abby
can,
said.
What you said?
okay,
She said that overwhelming the medical evidence says that it was killed instantaneously, that no very few minutes passed. And she didn't say
put it on the report.
she said there was minimal soot in the esophagus, and I can't tell you if that means he was alive or dead. I don't know that.
That's not a no, he wasn't.
That's
And they didn't ask a lot of questions about that when they were
So
talking
what's your
about the law.
objection?
My objection is for the prosecutor to say that I said things that were not in evidence.
No, I didn't say that.
So as long as he doesn't go there,
All I
then
said
I'm
was we
gonna
both
be
have
fine.
to. We both have to say things that are in
You
evidence.
both have to say
That's
things.
That's
you know,
true.
The implication is that perhaps I did not, which is not true.
I don't know. I'm not sure what we're arguing about right now. I'm not sure what your objections are
We're
about.
objecting, it's in my closing, which is very.
Yeah, that, all right.
Yeah, my memory of the medical examiner is that her response was that she agreed with us.
No,
I could be wrong,
I'd be wrong.
but I'm
All
gonna
right,
put that on the
look.
record now.
We,
And they can,
Mr. Lee gave you one, both your closing and it's proper to give some leeway in closing. So let's move on with it, not interrupt it
there
again.
are certain objections I'll have to make, and I just wanted to make sure that we didn't go too far. So we didn't go too far. I'm gonna keep going. Got it.
What I was saying is Shelby Shell will never get out of prison because he don't know how to behave. He's always kidnapping people or shivving people or promoting contraband, getting in fights. He's always having time added. He's not going to get out in 2039. Nope. Won't happen.
I want to continue precisely with where I was, which is talking about, was he even killed on the 17th? Okay. Well, as you can see in your instructions, that level of specificity is not something that's required. It says on or about the 17th day of February 2013. Talk a little bit about soot. Please, I want you to, when you go back there, look at the medical records, because there will be no statement concerning
CC doesn't work.
definitive times of death, how long did the individual, did Ronnie King survive while the fire was ongoing, if at all. Minimal levels of soot in the upper portions of the respiratory area. So, a few things here, then I'm going to get to some of the things that we didn't talk about. You know, we have a man walking away from a crime scene, and Mr. Cornett, if you recall, while he was up there were other people walking away from the crime scene, but I don't know how far that extends out. And that's a ways away from where the actual house was. So it would surprise me if more people didn't walk through that area. We have no idea, where the individual came from, and no evidence was presented either way about that. We heard Ms. Karen talk about phone records and Cellbrite interchangeably. We also heard her state that Mr. Cornett did not even review, she said, 1,800 pages of Cellbrite report. That's correct.
We object
have a
again.
witness here that is from the Kentucky State Police Electronics Crimes Branch, and that's his job. And he did review it, and he was here to testify about it. And some of the things that he said was, these aren't phone records. This is a retrieval of information off of a cell phone. We don't know what we're going to retrieve, what we're going to be able to get. Some things will come back and others won't. We don't get it all. It's not a phone record. It's a data retrieval system. You know, there was mention of Lee Miller and Shelby Shell working with Lee Miller. Mr. Corn testified that he spoke to Lee Miller and that Shelby Shell was not at work on the 17th or 18th or 19th. That's what he testified about. There was some mention about Dixon, and early on, and you know, through the trial, we were talking about Kevin Dixon, and well, did he say Kevin? Were you talking to him? And the reason why I started this by saying life and death is because we know Ronnie King was alive during this period because one of our witnesses, Jerry Mulkey, says, I was on the phone with him. My brother, Ronnie, he was alive. And 6 years ago, what she told the police and what was testified to that she told the police and they put in their report was that she said that Ronnie said Kevin at the time when it was happening, when the investigation was ongoing, immediately after. He said Kevin, and I thought that was Kevin Dixon. You know, something was made about Jimbo and Ernie, and you heard from witnesses that said things about Ernie, and a significant portion of them also said during that time they didn't like him. One of them said he'd made them get arrested. The other one, you know, they were mad at him. And stories matching up, you know, that talking about stories matching up, the blinds were not there. The blinds were not there. Shelby told him he was going to get the blinds, to burn the blinds because they had fingerprints on them. They're not there. I think that's a bad thing that they're not there. Stories matching up, one of the things that wasn't told or wasn't highlighted at least, is that the stories, each and every time, they originated with Shelby Shell. They originated with Shelby Shell. Who told Ernie? He testified. Shelby Shell told him. Who told Jimbo Collins? He testified. Shelby Shell told him. You heard a phone call. Who was on there? Shelby Shell. We're going to talk about that some more here in a moment. Ronnie King shot first. That was one of the things that Ernie Shell stated on the stand that Shelby had told him. Again, that wasn't highlighted. Shelby's telling him, I killed this man that shot at me first. There's no evidence presented that there was another shot concerned from the Kentucky State Police. And when Ernie testified about that, he said, yeah, Shelby told me that, but some of this stuff he went back and forth on. A bookshelf was shown to you. Because Ernie had said a bookshelf was turned over. Again, Shelby's the one that told him that, but he said a bookshelf was shown up. And one bookshelf was shown to you. Is there any evidence that that was the only one in the house?
Objection.
Another objection.
May I approach?
May I approach? Judge is getting ready to get mad. He's going to get big mad. What did LeBron say? He got big mad.
I'm sorry. I am sorry. I don't want to interrupt your closing. But when you say something like, was there evidence that there was anything else in the house, that's impermissibly shifting the burden from the prosecution to the defense. I would just ask
No, it
that.
does not.
It's
No, it does not.
that it was one
Let me tell you something, Scout. You spent most of your argument talking about things that aren't there, that haven't been done, that aren't evidence. He just happened to mention
I just have to make the objection,
observation
Your Honor,
on the
for
on, and this is an inappropriate corruption. Now you said things like
They didn't recover nail clippers, which are commonly used to collect DNA. There's not an ounce of evidence in the record that nail clippers are used to collect DNA.
Nail clippings.
Nail clippings. There's nothing in there.
That's why they take them. But nonetheless, Your Honor.
Now, listen to me.
Okay.
Listen to me. This is an inappropriate objection. And so we'll have a seat.
Woo, have a seat. Got mad. All right. This next one is, I believe, the end of the like they make it the rest of the way without getting objected to, and it has the graphic pictures. So I'm going to take the share screen down and I'm just going to play it. Is that okay? And that way we'll just instead of share screening, we'll just hear it now. I think that's best possible way we can do this without. And you guys, when I start playing, I'm gonna ask you to put a 1 in the chat if you hear it. That way we'll know. All right, put a 1 in the chat if you can hear them. They're not really saying anything yet.
Once more, I'm going to get back to right where I was. And that is moving on from things that were in that I had to touch on early to getting to this part. What's right in front of us, the evidence that was presented throughout the entirety of this case. Let's go to 148 Kelly Street, Harlan County, Kentucky. It's right there. That's where this happened. Bonnie King was murdered at 148 Kelly Street. And when we were trying to tell you this story throughout the course of the trial, it was disjointed. We had to start to stop. But these things happen fluidly. It's going at all times. And at one point, Mr. Corder even said when the investigation wasn't leading to suspects immediately, I was grasping at straws. I was going down every angle I could go down. I was chasing everything, looking at everything, trying to find out what was going on. And one of those things was, yes, Kevin Dixon, because as has been stated and was stated on the stand, and then Kevin came up, and that was possibly Kevin Dixon. But Mr. Corner said we looked into it. We pulled a video from Marathon. We spoke to people who were with this individual. And we had to keep searching. We had to keep searching. And the next significant thing that happened was Ernie Shell. Ernie Shell. He did speak to law enforcement. And he did come in to talk to Mr. Corner. And there he said, I've got to tell you, my brothers told me a story about Ronnie King. And talking about things that match up, let's do that. Let's talk about some of the things that he said had happened. First off, that the entry happened in a very unique way. Shelby told Ernie, I got into the house because I heard Ronnie on the phone. I heard him. And I heard him telling somebody when I knocked that he thought it was Kevin. So he took advantage of that. And he entered that house by stating that he was Kevin, not Shelby. He was Kevin. That's what he told his brother, Ernie Shelton. He told him that he zip-tied the defendant. So I zip-tied. And in the evidence that we showed from some of the pictures that were taken by the coroner, you can see zip ties on the victim. You see them. Matches up. He said, I duct taped him. Shelby Shell told Ernie Shell, I duct taped him. And we see from the pictures at the crime scene, he was duct taped. He was bound with zip ties. He was duct taped. And not just I duct taped him, but he told Ernie, I duct taped him around his head too. And we see that his feet are bound, his hands are bound. And he has duct tape around his face. And not just the duct tape, but a leather belt and zip ties. It says Ronnie began to break zip ties. That's what Shelby told Ernie. So he began to break these zip ties. He's breaking one after the other. 6 zip ties. Here we have the feet bound, hands and duct tape around the head. Zip tie. Zip tie. Zip tie. He kept breaking them.
616 Love, you're funny.
You know, he told Ernie that he went to look for a hammer, but when he came back, things were happening, and he grabbed a pillow. He put it over Ronnie King's head. He put the gun up to the head, pressed hard, and bam! He shot Ronnie King in the head. Here's the pillow. That was in the story as well. It matches up. Shelby Shell told Ernie that he went back to burn evidence because he thought that he had left fingerprints. And he did say shades. And all of the shades on that, they're gone. They're gone from the windows. No fingerprints recovered. He took $60-some, jewelries and rings. Ernie Koji said he beat up. Jimmy told me he beat up the jewelry. But he had Ronnie open up the safe. That he had knives and old money. A Smith & Wesson.
Thank you,
That as he comes and meets Shelby for the first time, that he does have a file. And that he's going down a gun, and that it was a Smith & Wesson
Thank you,
pistol.
Jay.
One of the pieces of evidence recovered from the crime scene is an empty Smith & Wesson box. There's no gun in there. So then we move on to Jimbo Collins. And he's telling yes, substantially the same thing, because who was he told by? The same exact person. The same exact person told him. And so their stories are substantially the same. That's correct. That he got into the house under the pretense of having sex with Ronnie King. That he used zip ties, but Ronnie King kept breaking the zip ties. That he duct taped him after that. That he had to use a whole roll of duct tape. Duct taped his mouth and his nose. And he shot him in the head. You heard from Mr. Corner concerning the Jimbo Collins interview that Shelby stated that he doused the body with gasoline. You later heard evidence that from the shirt, they found traces of gasoline. They found traces of gasoline on the shirt. Tried to sell him wheat pennies. Heard testimony from the family that he kept things like that, old money. And they found that on him. They found those pennies. So let's look at the pictures from the search warrant.
DNA does not show who he had sex with.
Found a gas can in the truck. Go on, please.
I know they're picking on me. I think it's
Old
funny.
jewelry, beat up. Beat up old jewelry. Just as had been stated by Shelby Shell to Ernie Shell and Jimbo Collins. Please keep going. This is a rolled up section of old money that was opened up by Mr. Corner to you during the trial. As he was putting on evidence and said, these are old wheat pennies are in here. Script from Yoakum Creek, which which is in Everett's, was found in that bag in Shelby Shell's truck.
I'm going to make a new member emoji. It's going to be big lips, I guess.
Inside the door, underneath
You guys
what would appear to be electronics,
and gals.
inside the door, a cigarette package that had 38 shell caliber hollow point bullets. Now check the medical records and see what type of ammunition, if any, is identified there. What was extracted. But then, after all of that, after these two individuals come and they say, we've been told a story. We've been told that story by Shelby Shell, and he's admitted to us that he killed Ronnie King. He wants us to buy some of these things from him. And the facts and statements that they made to the police matched the crime scene. Incredibly matched the crime scene. After all of that, what was provided to you was a phone call from Shelby Shell himself. Jimbo Collins asks him, and I want you to listen to this, please. You have the recording. 32 seconds in. You still got them pennies? Jimbo asks him. Yeah. Shelby says, yeah. What do you want for them? Just gas money's all I need. Just gas money. Jimbo asks him, did you tell Ernie that you went up there and killed that dude? Did you tell him? Yeah, he knows it, Shelby says. Yeah, he knows. Then he asks Jim, you think I can trust him? Talking about Ernie. You think I can trust him, Jim, for real? Two minutes into the tape, Jimbo tells Shelby, he loves you, man. He's talking about Ernie. He loves you, man. He don't want you to kill nobody, though. Shelby's response to that, he don't want you to kill nobody, though. Shelby laughs. He laughs.
I agree, Sandy.
2:27 into the tape recording. Jimbo says, if you do that again, is there any way you could not kill anybody, just rob them and tie them up? At 2:34, Shelby says, that's what I told him. I said, Ernie, I won't. If you get me some handcuffs. Then he says at 2:40, if you don't, I'm going to have to. You hear me? .247, Shelby says, if I can get some handcuffs, then I can get some stuff to tie them up with. And he follows that up a few seconds later by saying he broke 6 zip ties. You hear? 6 zip ties. You hear me? Jimbo says, Ronnie King did? And Shelby says, yeah. .25, Shelby says, I walked in, kicked him in the face, and said, you stupid son of a bitch. .357, he says, he being Shelby, when he broke the last one, I said, I told you, motherfucker. He broke the last one. I told you. 1 second later, I put a pillow over him. He grabbed a hold of me and I went, pow, you hear me? Shelby Shell. So Jimbo Collins that. 4:15 talking about duct tape. He said, I put a whole goddamn roll on him, you hear me? At 4:22, he said he broke it like it wasn't nothing. struggling for life. Now that's the evidence of the case. And the Commonwealth does have a high burden. It's beyond a reasonable doubt. It's a high burden, and it should be. But it's attainable. It's attainable. And I submit to you that we've reached it. Because if there is doubt, I don't think it's reasonable. It may exist. In a society, we don't have videos and affidavits and things everywhere, but we have evidence. And we've got Shelby Shell talking about it. And we've got Ronnie King, who is dead. And he died in a terrible way. And he died at the hands of Shelby Lee Shell. Killed him. He murdered him. Instructions state that in Harlan County for murder, Shelby Lee Shell killed Ronnie King by shooting him. We'll have to decide whether or not we presented evidence of that. And then in so doing, in shooting him, Shelby Shell caused the death of Ronnie King intentionally, and that he did not act in self-protection. Self-protection. Tied up. Zip tied. Bound by duct tape. Belts. Self-protection. And that's why, because of that, because it takes self-protection to get past, I'm asking you to convict on murder. I believe that we have presented proof beyond a reasonable doubt. And what you can consider, what you should consider, and what you must consider in coming to that decision is what has been presented to you through the witnesses, through the evidence, what's been presented to you. That's what you consider. I'm asking that you not convict on first-degree manslaughter, because I do not believe that Shelby Shell was privileged to act in self-protection. I don't believe the evidence shows that. Tampering with physical evidence, altered, concealed, removed evidence which he believed was about to be produced or used in an official proceeding. The evidence from Ernie Shell, Shelby Shell, Jimbo, went back to start a fire. I mean, they told you why Shelby said he started that fire. Following my fingerprints. Robbery in the first degree. That Shell stole jewelry, money, and other items from Ronnie King. All identified as Commonwealth's Exhibit 9. It's there. In the course of doing that, with the intent to accomplish the theft, Shelby Shell used or threatened the immediate use of physical force upon Ronnie King. I believe that we have provided evidence which I believe shows force was used upon Ronnie King. He's dead. He was tied up. He was bound. And when Shelby Shell did so, he was armed with a pistol, and that the pistol is defined as a deadly weapon. You know, one of the things that was talked about is our inferences and the types of evidence: circumstantial, direct, tangible. They all exist. Kidnapping. That in Harlan County, on or about the 17th day of February, Shelby Shell restrained Ronnie King by wrapping zip ties to the hands of Ronnie King, or by wrapping duct tape around the hands of Ronnie King, or by wrapping duct tape around the head of Ronnie King. And that the restraint was without Ronnie King's consent. and that in so restraining Ronnie King, it was Shelby Shell's intention to accomplish or advance the commission of a felony. Murder is a felony. Robbery is a felony. Those are felonies.
Like the choo-choo train.
But Ronnie King was not released alive. And unfortunately, he wasn't. He was not. Burglary in the first degree. That in Harlan County, Kentucky, on or about the 17th day of February, Shelby Shell knowingly entered or remained in a building owned by Ronnie King without the permission of Ronnie King or any other person authorized to give such permission. Entered or remained. He entered, according to Shelby, stating that he was Kevin. He remained in there even after he started doing these terrible things to Ronnie. And after Ronnie was dead, and could no longer even give permission, he came back, went in the house to burn it down. That's a crime. Arson. That in Harlan County, Kentucky, on or about the 17th day of February, Shelby Shell damaged a building owned by Ronnie King by fire. And it was Shelby Shell's intention to damage or destroy the building. That Ronnie King did not consent to the damage to the building. And that in so doing, it was not Shelby L. Shell's intent to damage or destroy the building for a lawful purpose. We've shown you the residence. Ravaged by fire. As the individuals on the stand said, intentionally started. Multiple places, intentionally started. There are some things that we do agree on, and that is the primary is this. This is a very, very important case. This is life and death. It is the life and death of Ronnie King, who was murdered in a terrible, terrible way. You have the evidence that's been presented to you. I encourage you to look at it, to study it. And I believe that when you look at all of it, you will find that we have met our burden beyond a reasonable doubt. A reasonable doubt. And I ask you to convict Shelby Shell for the murder of Ronnie King, for the kidnapping of Ronnie King, for the arson to Ronnie King's house, for tampering with physical evidence, for robbery in the first degree, for burglary. I ask you to convict him. I thank you for your time. I know it's been long. You've done wonderful. You've been out of here for several portions and in and out. And I thank you for listening and paying attention to the evidence and allowing me to speak to you.
We listened to the therapist. The therapist was the man who talked for like 2 hours. The paid
All right.
defense guy.
Ladies and gentlemen, it's going to be in your hands now. But first thing we need to do is let two of you go. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. We still have 14 viewers. As I told you in the beginning, 2 of you will be alternates in the event we had an emergency or someone got sick or something like that, and we wouldn't have a full complement of jurors. So at this point, I'm going to ask the clerk to draw two numbers at random, and
We don't need to hear that, do we?
the 2 numbers that are drawn.
All right. Okay. So what we'll do, we'll go ahead and for the next, 5 minutes or so, maybe 10 minutes, we'll discuss a little bit, take some questions, and I'll try to catch as many as I can. I've got the chat slowed down, so let's go over some questions that you might have. I'll answer as best as I can. If I can't remember, maybe somebody can help me. If something that's being said or brought up in trial that I don't know the answer to, maybe somebody will know it. So and we'll discuss here for a minute. Let me look at the poll right quick. It's 85%, and we've got it doesn't say how many people voted, does it? Actually, 82% yes, 9% not guilty, and 9% cannot decide. I made it too easy by putting can't decide, didn't I? So when we have our final vote, it'll be guilty or not guilty. And I'll change that here in about 10 minutes. But let's discuss a little bit and see the history of those boys. Well, the history explains a lot of what you see, but to me, their growing up, their history doesn't excuse a violent murder of an innocent man. And that's the way I vote. I think he's guilty. He told me what he did, so I'm a little bit biased, but if I'm looking at it, trying not to be biased and trying not to say who I am, or, it's like I said, you can't ask the jury to unsee something. So what I'm thinking guilty, by looking at the evidence. Just staying a bit off topic, but was Ern's agenda with Brothers Day, what was that about? I don't know whose idea but Brothers Day was. They both talk about it. One of them called it Family Day, the other one called it Brothers Day. But they were going to get together and spend the day together. That's all I know. As far as Brothers Day, that's what it was a day together, them hanging out. It turned out to be something different. Ernie says that, Shelby took him all these, you heard all the stories Ernie's told about him, trying to get T-boned so he don't shoot somebody and all that stuff. And Ernie knows how I feel about all his stories. And I've never wavered on that. I think he's a storyteller. And I think, from day one, I thought his ability to just tell the truth hurt the prosecution. And I really believe it did. But even with that, you've got this guy who, and they talk about these stories like, and this is something that, the jury wouldn't have privy to either, but they keep lumping those stories together like, well, everything they said was pretty much the same. But my statement, Ernie's statement, was not the same. I didn't say anything about a bookshelf. I didn't say anything about, damage done to the body or anything like that. Shelby never told me nothing like that. What he told me is basically what he told me on the phone. And you guys heard that. So all that other stuff that doesn't come from me. So when they say their statements were the same, no, they weren't the same. They were similar, very similar, especially with the details of, he put a pillow to the guy's head and pulled the trigger. That was the overwhelming bit of evidence, according to Detective Cornett, when he told me, hey, that's something nobody knew. And, what she was trying to say was, I am trying to persuade the jury. But what she was trying to say was, you made me lose my train of thought. I don't know what I was talking about. Something I don't even remember. Oh, the Detective Cornett kept it to himself. The pillow, yeah, and she was saying that, people in the community knew that there was a gunshot wound. Okay, let's say they did. They didn't know about the pillow. Like, the pillow was a, oh, wow moment. Like, he said he put a pillow over his head. Well, hey, there was a pillow laying there with a bullet hole through it right next to his head with blood on it. So, those are the things that are pertinent. I don't think I'm a jury foreman. I don't think the prosecution did a good enough job in hammering home those points. Like, the details, like, and they kept saying, well, Ernie's story was this, and Ernie's story said the bookshelf was turned over, and the prosecution was sitting there saying, well, was there only one bookshelf? Well, how about this? How about that's not Ernie's story? That was Shelby's story as relayed to Ernie. The prosecution should have stood up for that more, I thought. Should have said, hey, these men brought their stories to us. It was not their story. It was what was told to them by Shelby Shell. But they really never, that I remember, they never took that initiative. So I feel like the prosecution absolutely failed. I do think the defense did a better job overall. Of course, their burden is less. Proving somebody's guilt beyond a reasonable doubt is a lot more than, hey, let's throw everything we got at it and then hope there's one little bit of reasonable doubt in there. Because in those instructions, if there's a reasonable doubt in your mind anywhere, any reasonable doubt, you cannot vote guilty. So, April, I respectfully disagree. What are you disagreeing with? What did April say? Let me back it up. Back it up. April said sad but true. But back then, if you're out of control, they put us in SE. Oh, I don't know. I may have missed it. I'm terrible at following the chat, guys. I'm so sorry. This is the only trial that Shelby had. Shelby's telling everybody in the world that he had 6 jury trials or 7 jury trials, 7 hung juries, or it was 6 jury trials, 6 hung juries, and 7 judges. Absolutely untrue. Absolutely untrue. He had 2 judges. One judge either retired or was voted out of office. And the new judge came in, and he's been there ever since. And there was exactly one jury trial. The DNA, yes, I can see that. DNA would be messed up by the firefighters and all that stuff coming in, putting out fire, because they didn't realize there was a dead body there. They said that. One fireman came into the home and fell through the floor all the way to the basement. So, yeah, there's a good possibility that the DNA was compromised and some of the evidence could have been washed away by the firefighters, right? That's the first time I've ever even heard that mentioned. So that's a very good point. Very good point. Let me put that up, Serena. That's a good point. If Shelby Shell didn't commit the murder, then why did he admit to it? Surely he didn't just want to boast that he did it to make himself look big. No, Love and Grace, that's exactly right. He's like, the man had details about a murder that took place that he shouldn't have had details to. And he can try to claim there was a joke or a prank and he just went along with it. No. I mean, He never wavers. He never gets stuttered up or says, let me think. What was I supposed to say here? Nothing. None of that. Never wavers. He's stone cold throughout his whole admission. And he never mentions anybody else. Period. Never. I think somebody drove him there. And I think I know who it was. But that lady won't ever be charged. And I think he went in there and committed that murder. And yes, he did say he was going back. He went back to destroy evidence. The window shades, he specifically mentioned the window shades or blinds, whatever you want to call them. And they weren't even there. So he got them and took them. Whatever he did with them, they weren't there. They were never found. So, and by everybody's knowledge that's been brought forth, Ronnie King was a active sexual male. Would he not have blinds or shades in his windows? Somebody took them. How hard do you think it would be to tell details your flesh and blood brother, especially after having brother's gun put to your head? I do think Ernie struggled, but I also know that Ernie loves that spotlight. And like I said, once Shelby was arrested, Ernie was to the media immediately wanting to get a story. You know, and he's been telling that story forever. All right. Everyone without exception knows murder is wrong. Right. Like, you know, you don't take another person's life. You know, you don't do that. I mean, I got a nose itch, guys. Sorry. I'm not picking my nose. It's itching. Yeah. And, you know, he wasn't living there with no blinds or curtains. Like, that evidence was taken. Both desire, relevance, acceptance, a reason for living. Yep. Yeah. When you try to cover it up, you know what's right and wrong. Exactly. If there's a need for cover up, then you know you've done something wrong. 100%. 100%. And that's the thing, like, you know, why are so many people now wanting to make it seem like, oh, Shell's been misunderstood and it was set up for a murder. No, he wasn't set up. He murdered somebody, bragged about it, and got busted. Let's see what you got here. This is Lyric 0810. Do you believe that Ernie knew Mr. King was going to be killed prior to it happening? I do not believe that Ernie knew Mr. King was going to be killed prior to it happening. I don't think so. I don't think that. And if I did think it, I would say it. You know. And now the car evidence. Did you hear the defense in our closing arguments mention that car? The 2012 Dodge Caliber? We watched it. We slowed it down. Did you all see a Dodge Caliber? Could you tell if it was a Dodge Caliber? Could you tell if it was a man driving? If it was a short man driving? If it was a woman driving? If it was a fat woman driving? If it was a skinny woman driving? Was she long hair, blonde hair? Could you tell anything about the man or woman driving? Could you even tell if it was a Dodge Caliber? Yeah, you see the white plume of smoke they talk about. And that's another thing. It's in February. Many houses, especially in rural eastern Kentucky, have wood burning stoves, coal burning stoves. Now, I don't know. I'm not an expert. Maybe someone here would know more. But if you see the smoke, it's a white plume of smoke. If you look hard enough, you'll see the little plume of smoke come up. You can't tell what house it comes from. But if you, somebody answer me this, because I really don't know. You could probably Google it and find out. If there's a fire set with a ignitable fluid, what they called it, ignitable liquid or gasoline, because they found out later that one of them was gasoline, would that fire have white smoke? That was never mentioned. I mean, if it would, why didn't the prosecution, or if it wouldn't, why didn't the prosecution say something about that? Black smoke. You think, Steve, if black smoke, if it was a gasoline lit fire, no ring bell on doors? Buddy, back in 2013, shiz and giggles, I don't know if ring existed. I'm sure there were security cameras because the funeral home had one, but I don't think like the ring bells or whatever, I don't think those definitely weren't as popular as they are now. The smoke would be black. See, and she even says white plume of smoke. So I don't know why the prosecution didn't say something about that. Of course, they didn't know a lot of this evidence was going to be declared evidence until they saw, it mentioned. That car thing, I'm going to tell you, when they were talking about Lucinda's car and saying that it was in that video, I crucified Ernie right off the bat. I'm like, I called Kemper. I was like, man, you got to call me. I called him on Facebook, sent him a message, said, hey, you got to call me when you get up. I'm disturbed. I was really bothered. I said, Ernie was there, man. Like, they're saying this car was driving away. So, but I just listened to the defense attorney. I didn't watch the video. I mean, I jumped to conclusion, and, that was wrong with me. I'm trying to read some of this stuff. They were very inexperienced murder investigations in that little town. Oh, they were, Arkansas. They still are. Like, it's a small area where people know each other. There's not a whole lot of unsolved stuff anyway. I reckon there's like 4 or 5 missing people currently from Harlan. But, it's that kind of place, like everybody knows everybody. Something happens, White smoke often means material is off-gassing moisture, and water vaping, meaning the fire is just starting to consume material. White smoke can also indicate light and flashy fuels such as grass. Burning from inside the house would definitely be black, Stephen said. Gray smoke can indicate that the fire is slowing down, running out of materials to burn. Yeah, the fire departments are, you know, these are not paid. You saw the fire chief from Everett's. Like, these are not like, you know, the Chicago, New York City fire departments. These are people who donate their time to try to help people. You know, they don't have the best training. They do some training, I think. And they, you know, they make their practice runs and all that stuff, but they're not trained in murder and, you know, investigation. Like, they're there to put out a fire. That's why they ran in that home and tried to put out a fire. All right, so I'm going to reset the poll now. Take this poll down, end poll. I'm going to make a tougher poll. This one's going to be yes or no. Yes, guilty. I'm sorry, yes for not guilty. Or I'm sorry, yes, guilty. And no, we're not guilty. There you go. So you guys can vote now, or the last one ended with, I think it was said 83%. Let me look. Let's see. Last one was 83% yes, 9 couldn't decide, and 7% no out of 42 votes. So we got 57 people in here right this minute. So let's get at least 57 votes. Come on, guys. Yeah, he was the ex-mayor. He wasn't the current mayor, but somebody who used to be providing us a little bit of information actually said that once it was found out that he was a homosexual, that they got rid of him as mayor, and he tried to run a couple more times and lost. So who was his following as mayor? I don't know. I couldn't tell you. I don't even know where you'd find out. Right, Gwen Jenkins. Regardless, he didn't deserve to die. The victim was a former mayor of the little town of Everett. What we say, there was less than 700 people in the town. He was the former mayor. The jury, former apartment complex manager. And I guess the trial brought out that he was kind of an unofficial pawnbroker. He pawned stuff to friends and family, or for friends and family, you know. That's really all I know about him. Were they related? Were King and Shell related? No, not that I know of. I've never heard that mentioned anywhere, so I don't think so. Well, thank you, Rosemary J. Only 28 votes. Did we forget to vote again, people? If you voted earlier, vote again. Let's go. This is final. This is your final answer. Actually, tomorrow, what I want to do is have one more night of discussion about the trial. I'm going to open up a panel. I'll pin a link to the top, and people who want to come in and be respectful, are more than welcome. People are going to come in and cuss and, just try to create havoc. We'll just kick them and ban them and, hope it don't turn into that. I've seen that happen so many times. Last time I tried to have an open discussion is exactly what happened. And then, well, you didn't give nobody a chance. Well, I'm not going to let somebody sit up here and cuss, scream. I don't cuss and scream. Good night, Angela. Did you vote, Angela, before you left? Let me see where we're at now. We have 30 votes. Ooh, nobody's voting not guilty right now? Maybe you can come up on panel and hang out a little bit tomorrow night, Steve. We'll discuss what we've seen in the trial, good things and bad. And Stan, I have a question I have not seen or heard. Let me see. Just anything from Not Today or Kemper. I'm assuming that's who. Did they fall off the YouTube world? NT is the channel's still there. All the content's gone. Kemper started his own channel. I think it's Tales of a Lycan. That's about all he can come up with. Like I said, when we want to do a backup channel here, he's like, let's call it the Lycan Dog. I was like, I don't know about that. But so yeah, I don't know what they're doing now, but that's supposedly maybe both of them, at least one of them, is working with another creator to put together a big show coming up soon about how Shelby Shell was set up. And honestly, it just, if you look at it from, the outside world just looking in, like, why in the world would anybody go to Everett, Kentucky, murder a man that nobody outside of Everett, Kentucky, and no disrespect to Ronnie King, but nobody outside Everett, Kentucky has ever heard of? Why would somebody go there and murder him and frame Shelby Shell for it? Like, if you're going to commit a murder, a robbery, murder, whatever you want to call it, why set anybody up for it? I mean, if you're going to get away with a perfect murder, why does anybody have to take the fall? Why do you set Shelby up for it? Like, it just don't make any sense. It's just, it just don't make any sense. But a lot of things in this world don't make any sense. So I didn't say that, shiz and giggles. I said I wouldn't think many people outside of Everett's would have known who he was. You interpret things quite different. I've seen that from you a lot. I know you think it's out of anger. You think somebody went in there and killed him over anger. The only thing is, like, with a crime of passion like that, of anger, isn't there generally like a bunch of evidence? Like, oh no, you can have whatever opinion you want. I just notice, like, I don't, it definitely seems like a lot of overkill. And I know that's one of the things, if you watch all these TV shows, that it's it's a lot of overkill. Usually means crime of passion, or there was some kind of anger or love or something that caused so much overkill, right? And that's definitely one of the things that kind of thing usually factors in. But it also, there's usually blood spatter everywhere, and all kinds of DNA, and oh, we got to know. Good. We got 3% no. So we got 31 votes, 1 no. Uh-huh. But we're going to have an open panel tomorrow. Anybody who wants, you don't have to show your face. I'd prefer to see it backstage at least, unless I know who you are. I'd like to hear your voice anyway. That way I know, so I don't get, people doing crazy stuff over here. I don't know why people do that either, but they do. And they think it's like, boy, we got you. We showed some porn on your channel. We got you. So you can go back in and cut out that 2 seconds before you cut it out, and you don't even have to worry about it. Hey, we'd love to have you come on panel tomorrow if you want to. Like I said, that's up to you. No dirty pics. Yeah, no, no pressure on anybody. If you want to come on panel, wonderful. If you don't, hang out in the chat. Throw some tough questions at us. Is it also personal? I don't know what you mean, Rosemary. About to wear the stress ball out? I got a stress ball. Little basketball. Well, listen, I've always welcomed the difference of opinion. Even trolls. Like, if you just want to come in here and just flat out be a troll, that's fine too. Just don't be, don't use the F word over and over. Don't call any of the people who watch the stand names. Actually, just don't call anybody names. If you have to just call somebody names, and don't come on panel. Simple as that. Yeah. When we get out of here tonight, you guys go over there and check out Steve's channel. Are you live in tonight, Steve? Tomorrow night, I think I've got it set for 10 o'clock. Pretty sure. Let me make sure. Tomorrow is Friday, so I am probably going to take Mama C out for dinner. Why can I never find mine? Oh, there it is. Tomorrow night, 10 p.m. 10 p.m. So, all right, guys. Well, let's end the poll. Okay, I'm going to give you one more minute. One more minute, and we'll end the poll at 3:32 and 15 seconds. So we'll close it then, and then we'll see where we're at. Still got 34 votes in now. There's actually 3 not guilty votes. It's a far cry from 6 to 6, right? I don't know. And this one I was going to tell you guys about this. I'm going to look. This probably won't take a whole lot of time to get into, but This Robert Early McKissick killed Anthony Carter in Lexington in 2017. There was eyewitnesses, saw him shoot him. They went to trial, and there was 9 not guilty votes with eyewitness to a shooting death. 9 not guilty votes. Let's give Jimbo some kisses. You dad burn crazies. So after the hung jury, just a few months later, he pled guilty because they offered him 5 years. And he's already been in there over 4 years. So he was going to be eligible for parole like right away. So he went ahead and pled guilty. I think he's probably already out. But I figured we'd go over that. And, you know, I'm going to try to go to Lexington and get trial DVDs if they have them. And we'll go over that trial. And it shouldn't take long. And from what I've seen, the witnesses should be fun to watch. Yeah, StreamYard's pretty cool. It's if you are interested, I might be able to get you to come in earlier in the day and do a test run just to see how the sound is for you and everything. Gonna bong bing dance. I have to entertain the kiddos. TikTok is a crazy thing, that's for sure. All right, let me close this poll, and we are at 97% and 3% out of 39 votes. So $93 or 97%. Actually, 2%. How's it 97 and 2? Probably with the fractions, I guess. Okay. All right. Well, guys, it's been fun tonight. I appreciate it. Finally got to the jury, right? We saw those closing arguments. We will still a hung jury. It absolutely is. You got to have a unanimous decision for not to be hung. So there could have been 2 hung juries and 2 not hung juries, I guess, with that many. Is that right? No, 1. Anyway, but all right. Well, guys, we'll sign off here for the night. If you need anything, if you need to send me information or questions, CoachJimboC@gmail.com. If I can help you out in any way, CoachJimboC@gmail.com. And tomorrow night, 10 p.m., we'll be back here live on the stand. I'm Jimbo. We're coming live from the stand.